bright and early back on Karen Reed trial schedule time. Oh, I can't believe that we're just a couple weeks away from me having to be up like this just about every single day. But we are. I've been really, really skeptical about actually going forward on April the 1st, just given how much there is still to sort out. 30 motions just in Limine, and then more have come in. I've got the motions in Limine itemized in the show notes there, but since then on Monday we also got a defense motion to exclude a Dr. Judson Welcher, who I believe is a reconstructionist and accident and biomechanics. Biomechanics, you don't say. You don't. I wonder if he's going to have something to say about John's arm. Cause of injuries to John's arm. Commonwealth's motion to exclude Garrett Wing. Garrett Wing is a dog bite guy. He's a dog guy. I remember him. I know he went on Melanie's channel, Melanie Little. But I also saw a video he himself did. I think it's on his own channel. He's got this rubber arm that he uses to kind of demonstrate different holds and injuries and things like that. And I'll tell you, it's pretty compelling stuff. Commonwealth's motion to exclude Michael Easter. Mr. Easter is very interesting because he's a CAST guy. He's one of the FBI's former CAST team members. And CAST, if you're not familiar with that particular group in the FBI, they investigate cell location information. They're the ones that typically do the cell site analysis, like we're seeing over in Idaho with the CSLI information. But they're also often the ones that get geofence warrants. I think those might be fading in use now, at least warrantless ones, ever since I think it was the Fourth Circuit came out and said geofence warrants are they're a general warrant. They're unconstitutional. You're not allowed to do that. A dragnet search is kind of what they call that. I guess that would mean that even with a warrant, that would be a problem. So sorry, it is a little early still, guys. Gotta get the cylinders all firing before I'm really on it. So that's very interesting, although it doesn't look like that's necessarily what the Commonwealth is challenging. He seem to be challenging. He's got some opinions about this investigation. So I don't know if he's even going to testify about cell site stuff, but it seems like that would be kind of like a missed opportunity to not at least go in and review some of those claims that the Commonwealth had made in the first trial. A lot of information about John's phone and where it was and the limitations on signal in the area, the health data. I mean, this is exactly the type of stuff that the CAST team works with. So I'd expect him to know things about, like, I don't know, how reliable is it when someone's phone says they went up or down 2 flights of stairs at a certain time? And is that something that could happen by just driving up a hill? So anyway, it sounds like if nothing else, he's got some not nice things to say about this investigation that the Commonwealth doesn't want him to be allowed to say. And then the Commonwealth has also asked to increase the buffer zone. We had a buffer zone for protesters at the last trial. It was challenged on First Amendment grounds, and that went up, I believe, to the Massachusetts Supreme Judicial Court. It was upheld. Again, I got mixed feelings about the buffer zone. I understand the reason for it. You don't get to advocate to the jury, what outcome you think that they should reach. And so it's perfectly normal that inside a courtroom, you don't get to wear things like, hang him t-shirts, stuff like that. Even things like, there have been cases where Families of murder victims have wanted to wear like a button, a pin with the victim's face on it. The courts will typically not allow that kind of demonstration in the courtroom. So now obviously they want to extend it outside the courtroom, beyond the courtroom. There's definitely a limit where that is not going to be okay. But the purpose of it is because the whole point is to not have this type of influence on the jury. It's not a popularity contest. You know, the jury shouldn't be deciding whether she's guilty or not guilty based on how many people are showing up for which side. So, you know, in and of itself, I get it. I do. I don't have a huge problem with it, but they're now trying to expand the buffer zone, you know, pretty significantly in size. And it's some of it just seems a little petty. Like, yeah, they shouldn't be able to hear stuff in the courtroom. But just the mere fact that people are honking, people should not be getting arrested because of like honk if you support Karen Read. That's ridiculous. That's First Amendment stuff. You have a problem with people being on notice of those types of restrictions and things like that. So, yeah, definitely some shenanigans around this order, even if in general, the idea of having some type of restriction on protest, because this is a court proceeding, is probably going to be upheld. Otherwise, you know, there's still motions hanging out there, and of course, all the motions in limine. So we'll see what we get to today. I really don't know how we're going to do this. Here's kind of what I would expect in terms of the order of business. Some of these are not going to be objected to. In fact, like some of them, like the motion for attorney conducted voir dire, for the attorneys to be able to ask their own questions of prospective jurors to kind of determine, are you biased? What types of biases do you have? What types of life experiences do you have that might contribute to how you think about this situation? Both of the attorneys are asking for that. Both parties are asking for that. So they're not going to substantially argue that. Now, it doesn't mean Judge Cannoni's going to grant it. It's ultimately up to her whether she lets them do that or not. But just meaning, you know, some of those, there's not a whole lot to argue about. So I'd expect the first thing that they do is they go through and they identify if any of these are not objected to. If any of these motions, we can just take them off the table. We can agree that they should be granted. And then we would proceed to the ones that are disputed. And typically, I mean, there's no like hard and fast way to do that, but it's fairly common to go through all of one side's motions and then go through all of the other side's motions. But we may or may not do that. I really have no idea. Are we going to get to the expert stuff? I don't know. No idea. I have no idea. And just given that this is the Karen Read trial and that we're in this last minute flurry, I fully expect there's going to be more things filed today. You know, while we're sitting here waiting, there's going to be more things trickling in. So we'll just have to see. So I pulled out a couple of these motions that are on the docket. I don't want to go through all of them. I mean, we don't have time anyway, and there's far too many of them. But there were a few that stood out for me. See if I can pull it up here. Oops, nope, that is not what we want. Pardon me. Oh, here it is. Right here. So just a few of the motions that, see if I can get this bigger. No, that's not working. Oh, Dee Dee is my go-to source for the motions, but unfortunately doesn't always make them that easy to read. Okay, here we go. So this one definitely jumped out to me. The defendant's motion in limine to exclude false and irrelevant statements of Michael Proctor. Why does this stand out to me? Well, because we've been having a whole bunch of motions and arguments and filings and so forth, dealing with who's lying in court, dealing with misconduct, candor to the tribunal, all of those types of issues. And so this is an opportunity for the defense to go ahead and bring the court's attention back to where it should be, which is who has demonstrably lied, and not just maybe not said things the way that you like them or in the time frame that you like them, or something like that. You know, kind of around the edges in terms of the details of when and how and for what ARCA got paid. But no, like they flat out lied about what happened with Mr. Yannetti being in the school parking lot. And so I remember this. I remember this back when this happened during the first trial, where Trooper Proctor was basically doubling down on why he didn't like David Yannetti, and his justification was, you know, basically, well, you know, he's doing this type of stuff. He's a bad lawyer, mean guy, intimidating all these people and stuff. Went to harass his sister at her place of work, her school. And so, yeah, he made these allegations that when Mr. Yannetti had gone to the parking lot of a school where Courtney Proctor was allegedly employed, he, 1, refused to leave the school parking lot when confronted by a teacher, and 2, upon being confronted by a teacher, he asked about Courtney Proctor's whereabouts and asked whether she worked at the school. Both assertions are false, as demonstrated by the police report. So first off, of course, Proctor was not even there. This is just something he's going to have heard about from somebody else. So yeah, here's our context. One of his text messages about David Yannetti. I hate that man. I truly hate that man. He seems to have refocused that on Alan Jackson now, but you know, hate isn't zero sum, so maybe there's plenty to go around for others on the defense team as well. Asked to clarify on redirect, and during his response, he falsely claimed, you know, gone to the school, and apparently referencing rank and false hearsay, because he wasn't even there, that he had been asked to leave the parking lot but refused, that he asked somebody at the school if Michael Proctor's sister was working that day. He testified that Courtney thought she was, quote, being served, although there's no evidence that Courtney Proctor ever saw Mr. Yannetti that day. Let me go ahead and pull up the second page here. Here we go. And so then the court went in and struck it after they had a little sidebar. This was clearly not appropriate, but you know, the cat's out of the bag once he blurts this kind of stuff out. How you're supposed to unring the bell. So after the trial, once again now after the trial, as things are coming in, that's when they get the police report. See, if they had the police report at the time, they could have impeached him with it. Brady, knowing false. Curious when and if Mr. Lally had this police report in his possession when he elicited that testimony from Trooper Proctor and didn't correct it. That's a NAPUI problem. Those of you that have been following NAPUI and Glossip and everything, it's come up in the Richard Allen case. Supreme Court cases dealing with prosecutors knowingly eliciting false testimony and that being a due process violation. So they get the police report, directly contradicts every false allegation from Trooper Proctor's testimony, shows he made completely false statements under oath. Incident report states that the principal of JFK Elementary School contacted Patrolman Eric Kaskovich, the school resource officer, to make him aware that Mr. Yannetti and Brian Loughran had been seen in the school parking lot that day. That's what I remember from Lucky's testimony. He asked to meet there. It was his suggestion that's where they meet up. The principal informed Patrolman Kaskovich that Mr. Yannetti and Mr. Loughran were not approaching the school, students, or staff, and that she only wanted to make Patrolman Kaskovich aware in the event that things escalated or hit social media. Patrolman Kaskovich responded to the school and spoke to the principal and others at the school. He detailed that it was never reported. It was reported that neither individual ever approached the school, students, or staff members. He observed them pull into the parking lot, talk for 5 to 10 minutes, and leave the parking lot in their separate cars. The patrolman wrote that none of the four ever pointed at or approached the school, students, staff, or students. Trooper Proctor's claims that Mr. Yannetti was asked to leave, refused to leave, inquired about Courtney Proctor were all completely fabricated during his sworn testimony. So, yeah, it's kind of important that we call out this type of misconduct and remind the court when it comes to the battle of whose hands are clean. Whose hands are clean? The Commonwealth does not have clean hands. And moreover, the Commonwealth has duties as a prosecuting attorney to be truthful. So good motion there. Good motion there. Definitely one that I enjoyed. Once again, of course, the Commonwealth is seeking to preclude third-party culprit defense. This is largely, not that different from what we've heard before. I mean, obviously this was challenged prior to the first trial as well, had a whole hearing on it. The court basically said, we're gonna wait and see how it unfolds. And ultimately, as the trial unfolded, she was, I think, a bit more tolerant as things went on, of letting them develop it. But the question with this third-party culprit defense, the Bowden, there's no doubt they get to go into that. The Bowden defense is what Massachusetts calls this kind of hybrid version, where you get to challenge the police investigation. You get to argue, hey, they didn't adequately investigate certain other leads. And so because of that, there's reason to be skeptical of the results that they got. But it's not specifically pointing the finger at another person. It's not saying that other person did do it. It's just saying you didn't rule those people out very well. This motion doesn't address Bowden. It's just saying, naming people. And I talked about this the other day when I went on, I think it was when I was on with Mike over at the Young Jerks. And we talked about how it looks like the defense strategy might be shifting a little bit. And the clue of this was in the sit-down interview that they did, Karen and Alan Jackson did with Ted Daniels. And they were asked, in your opinion, there have been a few names that have surfaced in this third-party culpability theory. Who do you think, if John was beaten up and attacked in that house, did it? Defense counsel uttered, "We don't know." The defendant quickly echoed, "We don't know." And they added, it's not for us to know. Someone other than Karen, somebody other than Karen is responsible for that, for the killing of John. But who was it specifically? Others know, and they're not talking. So this looks like a little bit of a shift in the strategy away from specifically identifying, is it Colin? Is it Brian Higgins? Is it Brian Albert? Is it Chris Albert? Like who exactly is it? It looks like that strategy is shifting, and honestly, to me, that seems wise. I'm going to go ahead and switch it over to the stream here because it is getting ready to get started. Oh no. Oh no. Thank you. Thank you, sir. No, we're going to watch The Fan. Well, my bad. Sorry for jumping the gun on that. Ugh. Anyway, I think that's a smart strategy, and part of the reason why I haven't made my video yet about the Turtle Boy juror interview. So I will. It is coming, but one of the things that came out of that was this idea that, well, they hadn't really proven who did do it. You know, if she didn't do it, they weren't convinced that she had necessarily established who did. And of course, the defense doesn't have a burden of proof. It's not their job to solve the crime, but that is the risk. It's the risk that you give that kind of misimpression with a real specific third-party defense like that. That it gives the idea that you are taking on a burden of proof, that you are undertaking to prove something, and that by wanting to prove it, you need to be able to back it up. And so that's definitely an area where I think there's room to refine it. And frankly, I think that's smart anyway, to make it a much more nuanced type of defense that isn't trying to point the finger at anyone in particular, because we don't know. I mean, the reality is simply there's multiple people that had the opportunity, there's multiple people that had the motive, and there's lots of people, if we're looking at the suspicious circumstances and behavior, all the butt dials and the meeting in Lank's driveway and all of those types of things that speak to the cover-up, there's a lot of people that, there's incentive to circle the wagons and protect. So, having said that, if I'm going to try to point the finger at any one person, who do I think it was? I'm telling you guys, if I'm pointing the first finger at one person based on what we've seen, I think it's Higgins. He's the one with the clearest motive. He's the one that was getting mad at the bar. The getting rid of the SIM card and the cell phone. He was having communications. It seems like that puts you in a little bit more of a, not so much a witness type of category. It puts you as more of at least could just be co-conspirator stuff. All right, it looks like they are getting started. Let's go ahead and get that up. That sound is extremely quiet. Can anybody hear that? I can hardly even hear that. I'm going to see if I can find it on another channel. Okay. Hang on. I'm going to switch. All right, hang on. Trying to get this treated out. Let's watch this one instead. Oops. Okay. And I'll just speed us up a little bit so we get up to speed.
22117 Commonwealth versus Karen Reed. Can I counsel identify themselves? Starting with Commonwealth.
Good morning, Your Honor. Laura Block.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Adam Malik,
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan, Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson, Initiation.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Mr. Alessi.
Good morning, Ms. Giannetti.
So happy to see you
so
today.
There's a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel.
Really?
And I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So, I find or conclude that that was a material misrepresentation.
Oh, Jesus. Material.
And that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And
She's going to exclude
before
them.
I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So
We're having an ex parte sidebar. What on earth is this? Because she's going to try to ask them about their defense strategies and theories. What is this? Oh, man. Shall we move on to that Michael Proctor motion next? What do you think? You think that's going to happen? Oh, my Lord. Material and deliberate misrepresentation. Don't know what to tell you guys. Don't know what to tell you. I mean, that particular motion was always going to be what to hang her hat on, not paid for. It's not 100% true. It's not 100% true. They paid for their time. Didn't pay for the substance of any of what they did, and that still remains true, and that's really what's material for purposes of whether they're biased or not. So, boy, how many misrepresentations has the Commonwealth made and continues to make? And what do they get? Nothing. Absolutely nothing. She barely even calls it out. I can't stand that. I can't stand the fan. Can't stand the fan. Barely even calls him out in her pleading when it happens. You know, Mr. Brennan making that claim about Mr. Yanetti's extrajudicial statements that it turns out were in fact made in court. They were not extrajudicial. Why is that not material? Mr. Lally certifying he had provided all of this discovery after making a reasonable inquiry, and then subsequently produces video after video after video, including, you know, the inverted one and all of the shenanigans with that. Yeah. Yeah, Mr. Alessi is dumbfounded. That's right. Welcome. Welcome to Canton.
So, there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So, I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Mr. Yannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the
So she's going to
apparent
boot
lack of
ARCA.
candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So, I'm not going to tolerate false statements, any stretching of the truth.
But you are
no misleading
from the
distortions.
Commonwealth.
There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll
this
move
was
on
just a
to
lecture.
Mr. Alessi, you didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Why did we even have that sidebar? Did she think Karen was going to say, sure, I'll boot Mr. Jackson, and then she would be allowed to remove him? Was she thinking she was going to get a waiver? I think she was thinking she might. And so not doing that, that means she's doing nothing. She's just lecturing them.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, as cause of death, you need to be a medical examiner, a forensic pathologist, or both.
All right, guys.
Conceitedly, Dr. Wolf
I'm going to
is not
try
a
to
forensic pathologist, and
change.
he's not a medical examiner.
Ugh.
So I'm going to just put
Hang
aside
on.
for the moment the cause of death. I want to speak specific, because he's got to be able to.
Hang on, guys. I'm going to try to switch over to Boston 25 and get a little bit better sound, hopefully. This is kind of a constant thing.
The applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it, but the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record.
I don't know
he is
that it's
qualified.
irrelevant. As much as
It's
I love
not enough to say you're
Mr.
a
Alessi.
neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury.
And you have the Commonwealth
So
trying to
in terms
exclude
of
the manner. So how can he testify to manner?
The paragraph
It
that
isn't
I was
manner.
just citing in his findings says, based on the findings of his autopsy, It is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell
Well, this is the
backwards,
issue.
his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards?
Yeah. No,
A
where's
neurologist
the
can't
support?
determine that is a manner of death.
that the ground was
He
frozen?
provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that?
Well, it's
There's- and it's also not
it's in
in
his
the
theory. I mean, they're
autopsy.
trying to present a theory.
And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night,
Oh,
which
boy.
is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and
review.
information. But it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's
That's true.
unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this
'Cause he
study
can't,
talks
'cause
about
he's not a forensic
mechanisms of
pathologist.
injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries. So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points.
Frozen ground. Please focus on the frozen ground.
Dr.
It's ridiculous.
Says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts, it's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin, and in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman, it's the same with other experts, where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the 2 prongs of the Daubert inquiry?
All right, thank you. Mr. Brennan?
Oh, Mr. Brennan. I don't think he's going to win this one. I think that there's definitely aspects where he should. But yeah, the mechanism of injury does matter. In and of itself, that is relevant. The Commonwealth gets to have a theory of how John O'Keefe died.
Please.
That's not the manner. I think he's got a point there.
Attorney Leslie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury.
Okay, I buy he's
Improving
seen a lot
outcomes
of
in
head
severe
injuries,
injury, PEG, SOD,
so he can
also
testify
principal
about what
investigator,
he's learned from
IRB
that.
protocol, brain pathology.
But the same thing,
He's
of course, has to
well-published.
apply to Dr. Russell.
His book chapters that he listed anyways list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies,
Oh, that's highly
complication
relevant.
of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through. But
Well,
you can see that he
you've
is,
gone through a lot of them,
well published,
and
over
I'm not
70
quite sure
articles.
why.
Presentations specifically on
Read his
fractures,
presentations now.
basal
This
type
is like a
injuries, number
Lally.
5
This is a
on page
Lally
13.
argument.
Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references.
If this guy's a shaken baby guy, he should
Lectures
be
and meetings,
disqualified.
many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead.
Oh,
Dr.
treats
Wolf treats
patients that are already
in
dead?
Trauma.
What sort
who
of
some survive
prognosis do
and
you
many
think those
die.
patients have?
So he is intimately familiar, not just with looking at a deceased in a lab. He's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. La Posada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it. But this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his
Cute.
proposed testimony. He is intimately familiar with countercoup, having treated tens of thousands of patients, and he understands in countercoup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of countercoup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Leslie, anything final?
Yes, thank you, Ron. Mr. Britton. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death.
Homicide.
And that is the distinction.
He wants to come in and say
emphasize, Your
homicide,
Honor.
'cause
Manner
Scorbella
of
wouldn't.
death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Dalbert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
The Commonwealth has moved to exclude manner of death. They're saying it's not relevant because they don't want Dr. Scorty Bellows' determination
At some point,
coming in.
arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of
No,
paper,
it doesn't matter if they
the
fell.
manner of death is based on my thousands and thousands of patients and my years and decades of experience seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay.
That's
Thank you.
that's
All right, so we
silly.
have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on
course
this
there
motion.
is.
Thank you, Your Honor, if I may. This is
They've got a chart of
relatively
the bumper
straightforward,
sprinkles.
Relatively short.
I have a question. Did you use this last time? It
We
looks like,
We attempted to use it, we had it last time, it was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
did she adopt it? Was there, okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead, I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial, no dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with
Demonstrative
that, if I
don't
allow it
usually
as a
go back.
chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to
decide now whether it's admissible,
I
and
don't-
and I couldn't, but what's the nature? Is this something,
The court will call, this deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
and this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attendant to the glass in the
That's
bumper.
plastic.
Okay.
The
Judge,
glass in
that's
the bumper, the glass that
plastic.
was found at
This
the
is glass.
at
Try to keep
34
up.
Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find
Yeah.
some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its admission at the right time.
All right. What's the objection, Mr. Brennan?
That testimony is always difficult to follow. Lab item number this, which is different from the exhibit number, and they don't describe it.
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also
Why
it
not?
doesn't give the full picture
If they found
of the
it.
actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony.
Well, then
I'm
check
open to
it.
discussing chalks with
That's
the
your,
defense
that's your job.
and
Point out where it isn't.
perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
There's not an evolving
All right, so,
nature of glass.
Mr.
Glass
Johnson, what
is
I'm going to do is
glass.
just hold off.
Theory
Hold
of
off and
glass
see where the evidence
can
is,
evolve.
what the two of you talk about. Maybe there's some agreement you can come up with regarding this. It's just, I need to hear more of the evidence again.
understand, and
And I'm going to read the transcript, so that will help me with
I think it
this.
makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of
Yes.
seize the day.
Thank you,
Ms. Hanley.
AJ.
So I do think that if the court would keep an open mind.
Sure, I'll-
When Ms. Hanley testifies, then that would be the appropriate time.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great, thank you. All right, so no action taken on paper 558.
Just flat out reference the trooper's name
So,
shouldn't be on there.
One question, the
Why
next
not?
motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the
No.
Aruba
Read the motions.
witnesses?
The defense motion is
I'm
about
just wondering if they're
Aruba.
hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though.
The defense motion is about Aruba. We got impounded on the Commonwealth's motion, but it appears to be about John's kids.
So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited, this argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not
No, Judge, it
include the
doesn't.
Commonwealth's number 11.
They're different
the
motions.
Qualls, Binns, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
No.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We do
Okay.
not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it, but in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
That's
There we
smart
go.
Whatever.
because nobody
All right.
bought it
All right,
anyway.
so Mr. Brennan, you can have a seat again, and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief.
Judge, that was the defense motion. He doesn't need to argue it now. We just got a stipulation he's not going to admit it. So it's his motion now.
If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood, thank
All
you.
right.
For somebody
Right,
who
so
is
that
so
was
like frustrated about
559.
efficiency, she is so inefficient. Are you going to deal with the Commonwealth's motion now, the one dealing with the kids that you brought up, or are we just going to skip around now to something
The
else?
defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
I would think she would have the right to attend. Should she not have the right to attend last
Your Honor,
time?
The defense is requesting that it exercise its broad
part of the
discretionary
trial.
powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client attending it.
Yes, Your Honor, attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. I think, would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we decide. We may have to do it all at once.
I do
So-
think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a
Yeah.
sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of
Yep.
juror time.
Good
Having
argument.
it all happen in one fell swoop.
Okay. All right, so let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars.
Yeah, it's never going to be
All right, so
representative
defendant's
because
motion
it's
eliminated
not
to
snowing.
exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion.
Do not zoom in on his papers. You want to get the cameras booted?
The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but, so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was
Yes,
this
it
a
is.
deliberating juror?
I don't know. She was, or he or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right, so obviously is not something, it should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed.
That's what she's telling you, Judge.
Because the way that they wrote it, it says all witnesses.
God, why is she so
I'm
snotty?
guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to
That was a
watch
partial
our
objection.
experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to? I'm
Mr.
concerned
Brennan didn't
about
have to
after
put
the
his
evidence is
objection,
closed.
partial objection in writing.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing.
Entitlement?
The defense tries to take an opportunity to provide an unsolicited bashing on their targets.
So the mob clients could
They
just come in
named
there and sit and eyeball the
Higgins,
jury and that would be
Albert.
fine?
They invoked those names, they characterized third-party culprit, and they suggest that some anonymous person
Clearly broad discretion by
was
the court.
uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed. The sequestration order has
So you
ended,
think the
and
gang
watch the
members
closing.
should be able to come in, hang out in the courtroom and
Grace
stare down
can
the
be
jury?
offered in these
That ain't the
circumstances
law,
sometimes,
dude.
And that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly, I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair.
The
It's
family
just.
is allowed to attend.
It's graceful.
The
And I
McCabe's
think
and the
that Ms.
Alberts
Reed's family should sit through the court
are not
testimony, even if
family.
They're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Yeah, the information that the Massachusetts State Police and the Norfolk County District Attorney's Office specifically wanted them seated there, that the intimidation was by design. Yeah, I think that's pretty important, and you do want to make a record of that. Sorry, but this is nonsense. Of course, witnesses do not have carte blanche to be able to sit in the courtroom. Like, absolutely. The court gets to protect the fairness of the trial and the fairness of the process. And I'm here to tell you that in situations where there's a risk of intimidation, like mafia cases, like gang cases, where the jury is sitting there concerned that they're going to have a target on them if they reach the verdict that gang or that mafia or whatever doesn't want, they're not going to be allowed in the courtroom. That is fundamental. So, this is a ridiculous argument, and just trying to conflate these people with the family members. They're not the family. They're not the family, and they don't have an unqualified right to bring whoever into court that they want to. Oh, I wish we could hear this record, because, yeah. Interested in how they got this information about the coordination to have them sit there. Well, yeah. And now once again, we're kind of lumping the motions together. The defense has a partial objection to the sequestration motion because they want the experts to be able to attend. Okay, that's fine. It is kind of obvious, Judge. But when Mr. Brennan had a partial objection to the use of chalks, you did not require him to put his objections in writing.
I'll take a closer look at both of these and have something later.
So let's go ahead and just take a note of if she's deciding
All
like
right,
any of
so,
these at
Ms.
all.
Dean Eddy, I
Everything
think
is
this
getting
next
kicked
one
down
might
the
have been
road.
yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay?
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by agreement.
So if we take out the voir dire payments, that means what's the total dollar figure now? The Commonwealth is going to try to get up there and say because
So
they were paid,
566,
what, $5,000
defendant's motion
for their time and travel?
Panel voir dire.
that they're biased. That's
Without
not going to
doing
go
that.
well.
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on?
Of course you
panel
will.
voir dire.
Oh, is it obvious?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being
Seems like
able to
everybody wants
panel-
it.
impanel a fairer and more comprehensive jury.
Okay, what's the Commonwealth's position?
They're both asking for it, so how's he going to object to what they want?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that
Well,
seems to
you can
happen
keep
the
yourself in
standard
line, can't you,
times
Mr.
I've
Brennan?
engaged in. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from.
You do
panel
both.
voir dire, consistently, it's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with, and jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it, and if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we've got a good backbone to start with.
So let's do that. And what Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do
Something last night was
extensive voir dire at sidebar.
Was there something last
and a
night? An
questionnaire.
interview with Courtney Proctor and
So
Elizabeth Proctor? Is that
566
what you
then
heard
is
about?
denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So,
Does AJ
is there an
know this
objection to
was a
that,
little
Mr. Brennan?
again?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides.
570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses.
Let's go. Witness
right.
intimidation.
Thank you,
This
Honor.
one was impounded, so I mean, we know what it's about, but
The first
we
trial,
don't get a lot of details.
I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable.
Yeah.
There are clearly,
Good qualification
as we
there.
all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable
I
cause
understand
standard,
that.
right? Okay.
But notwithstanding
my
that standard, the question was
Nitpicky.
she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that. and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial.
7 months later. That
And they knew this.
sounds
And
about
they
right.
didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So
He opened her own door.
The court did make that ruling, that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another, walking into court and basically lambasting the defense, for all intents and purposes, about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, which is, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan?
Excuse me for a moment here. Just going to pull up my notes from the last trial.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me.
Oh, geez.
It wasn't just
Those-
last
those-
night
those
when
pearls are gonna
Tony
crumble
Jackson
pretty
and his
quick here.
colleagues appeared on a documentary where Miss Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years.
Well, a grand jury
In
didn't
fact,
think
Mr.
so.
Carney has over a dozen indictments for just that.
The grand jury, a bunch of
You've had
dum-dums.
an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks.
Yeah, they
if it
get to challenge
pleases
the
them
witnesses.
and fits their narrative,
Big.
is something I can't just sit by and listen to. The Commonwealth.
In
the
other words, you have
prosecutors
no
weren't
legal
outside
argument.
patting their bloggers
So you're
on the
clutching your
butt for a
pearls.
job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations,
How dare he ask
That opens the
open-ended
door.
questions on cross?
and it will open the door again, I suspect.
What on earth?
And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention.
They're so clear that you can't say
of
what
raising
they
a
are.
collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Well, I know the first time it came up, I found in my notes
if
was
I may
very
very briefly-
early in
Sure,
her
Just give me one
cross.
second, I want to take one note, okay?
Of course.
When they were asking about communicating with each other, with the other witnesses, you guys were chit-chatting a lot. And she says, yeah, we talked about the
go ahead,
harassment.
Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say,
Yeah.
bash witnesses.
The projection
Use
is a
this
bit
as
much.
as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
All right, well, I can't find in my notes real clearly
All
the
right, the
second
next
time when
one
the
is
door
paper
was open.
571, and the Commonwealth's corresponding is your number 12, our paper 586.
Maybe that's it. That is the
So the
context.
defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol
Of course, I speak to
concentration
them all the
conversion,
time
and
about the
corresponding
vicious
retrograde
harassment we've been
extrapolation
receiving.
analysis.
The vicious harassment.
So who's arguing this for the defense?
In your
Because I'm going
conversations
to
with
ask
Chris and
you
Julie Albert.
whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first, and
All
we
right.
would respond, including with regard to my motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
So this is like the same issue that also came up last time.
Your Honor, paper number 12
it's probably gonna
seeks
come in.
to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth vs. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
Yeah, remember the witness testified they don't
Mr.
even
Alessi.
have alcohol swabs in the ER? Like we were supposed to believe that? Like they just routinely swab people with iodine like you're supposed to do?
Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy-dixit in saying they're reliable.
Ipsy-dixit!
When there is a lack of the information of the factors I just rehearsed with regard to the matter.
That's been
And
Melanie Little's
another key
theme.
aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in the serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B,
Guys,
terms
ipsy-dixit
of
is Latin. It means he himself
changing
said it.
that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C
Meaning it said without basis, foundation, just on your own authority.
also
Because I said it,
mentions,
therefore
and
it's
this
true.
is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't
Yeah.
know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
They raised
Should
the
be excluded.
accreditation last
wanna
time, and she
respond,
said
Mr.
it went to
I would suggest the
Wait.
court look to Dr. Fowler's testimony. He testified how blood was taken,
but not knowing
how it was
method does
preserved,
seem to
what
matter.
tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay,
May I just respond briefly?
sure.
Thank you, Hunter. Your Honor has often said that this is a new trial.
Yes.
The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination
He was great.
clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
He was the guy, the retrograde extrapolation
I think
witness
we have
that
time
was,
for one last motion before we take the morning recess.
was
Paper number
practically
574,
witness.
defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed.
It was
That's
impounded. He
574
has
is
to
allowed, Mr. Clerk.
state what that is, of course, who.
All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
We didn't know it was Richard Green. Might have suspected, but didn't know. But she had to make sure that's public, even though that was previously impounded. Yeah, you know, with all of this publicity and everything leading up to the trial, so difficult to manage. All the information coming out, huh? Yeah, Mr. Roberts. I remember Mr. Roberts from the first trial. He had, it was like a golf shirt, wasn't it? Like his work shirt. And he didn't seem to be a fan of retrograde extrapolation at all. Was very willing to concede that it depends on all kinds of different assumptions that have to be made. You know, gave him a wide range of what the potential blood alcohol level was, even based on those assumptions. He was a great witness for the defense in many ways. So I haven't seen. I know the Commonwealth's witness list is out. I don't have it right at hand, but I assume he's on it, just because I don't remember anybody specifically calling out that he's not. And if they had like substituted him with a new analyst to redo the retrograde extrapolation, I would think that would have been noticed. So I guess we're gonna get him again. And he was pretty fun. So I guess we're just going to sit here and listen to the beep while they talk scheduling. You know, I'll give her some credit. They do seem to be working through quite a bit of these fairly quickly. I was a bit surprised that the Commonwealth has gone ahead and conceded on the Aruba. The Aruba witnesses are not going to bring that in. It's smart. It's smart. That was it was not a good theory. It really didn't help them. It made them look like they're really reaching. They're just really stretching for a motive. The fact that they got that admitted as evidence of motive was really just it's so out there. So based on that, it looks like they're going to, you know, modify their theory. They're not going to get into Aruba per se. They just want to generally establish he was intending to end the relationship. And so, you know, that's her motive. I mean, again, I don't get it, you know, is she a psychopath? Seems unlikely. Doesn't really have the type of record, you know, that you associate with a lot of antisocial type of behavior. But, you know, that's essentially kind of what they're alleging, is that, you know, somebody's going to leave you and you don't want them around enough to like kill them. You just let them go. Like, you don't have to kill them, right? So they're basically suggesting it's this massive, such a massive ego injury that she just went ahead and killed him, I guess, instead of being like, great, see ya. See ya. Just kind of trying to go through and see what we've gotten through already. Quite a bit.
All rise for the court, please.
You are muted.
All right, so we're going to go ahead and go into the recess. We have made it through a substantial
We'll be recessed 15 minutes.
number of the defense motions. Let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 of the defense motions. 1, 2, maybe 2. Blood draw of the Commonwealth's motions. So, you know, she is making some progress here. I think part of the concern is that she isn't ruling on quite a lot of these things, like demonstratives, saying you guys need to go fix it. If they could fix it, they wouldn't be having motions. Okay, seems pretty clear that the Commonwealth doesn't like the exhibit, because they know the defense is presenting the information in a way that makes it clear and easy to understand. And so what specifically does he not want them to hear about the glass? No, judge, not the 47 pieces of plastic, the glass. The glass. Different issue. He doesn't want the troopers' names, the sources of each of the pieces of glass. He doesn't want that to be associated with the item number and made clear and easy for the jury to understand. He says that's improper. Why would that be improper? Why would helping the jury understand the chain of custody of these items possibly be improper? Well, I can imagine he might not like it because it might make them look bad. Might make them look bad if certain pieces being discovered in certain time frames, you know, might tend to support a defense theory of planting. The bumper sprinkles was always going to be one of those areas where they have a little bit of room to develop that, don't they? Because that, I remember from the first trial, that was compelling because the bumper sprinkles don't match the glass that was found at the scene, the tumbler glass, the broken piece of the rocks glass, as they called it. So where did those bumper sprinkles come from, and who found them? I remember that, if I remember correctly, was the MSP themselves, the evidence recovery team, when they came out and did the examination of the car. Weren't they the ones that recovered the bumper sprinkles? Because I remember we had this whole conversation about how the car had been, apparently, under the Commonwealth's theory, driven to 34 Fairview, where the bumper sprinkles were deposited, right? Under the Commonwealth's theory. She hits John, breaks the glass, leaves bumper sprinkles. She then drives all the way home. She then drives all the way to Jen McCabe's house. She then drives all the way to John's house. Oh, wait, no, she drives to John's house first. No, she drives to John's house. Then she drives to Jen McCabe's house. Then she drives to Dighton. Then the car is picked up in Dighton, put on the flatbed, and towed all the way to Canton, and since in the Canton Police Sallyport. And during that entire period, while it's snowing, I mean, I remember that snow in Dighton. That was some very impressive powder that they had in Dighton. It was very thick snow, getting up to like knee level. That was a lot of snow. And that all melted off the bumper, and driving down the highway at whatever speeds, and those bumper sprinkles remained there on that bumper that entire time. It was always a little bit difficult to believe that. It just doesn't seem to comport, I think, with most of our expectations of how things behave in a moving vehicle out in the weather and so forth. I don't know. I can't say I've driven around with glass on my bumper. I don't know that I have a real personal experience, but I do know we've got these trees outside, specifically this big Atlas cedar, it's called, Cedrus atlantica. It's a beautiful tree, but it sheds a lot. It sheds all these needles, and then it's got a very small cone. It's constantly shedding stuff, and it kind of goes over the driveway a little bit, and so it's fairly constant for those little things to fall on the cars, fall on the truck, end up on the bumper. And I don't always religiously brush off the car before I go drive it away, but typically what happens is that the act of driving, the way that the air moves over the vehicle and stuff, I mean, whatever, it'll all blow off. It'll all blow off. Now, is that equivalent? I don't know. I don't know how big these bumper sprinkles are. I don't know what they weigh. A couple few grams, a couple few ounces. Maybe it's different. I don't know. Maybe it's a mass issue anyway, and not a weight issue. I'm not sure. You physics people in the chat can tell me that. But just always a little bit hard to believe that particular theory. So, yeah, willing to entertain the possibility that the bumper sprinkles were planted. So tying that maybe to something else that was discovered at the scene by who? By which trooper? When? After the bumper sprinkles, maybe? I don't know. But it sure seems that, like Mr. Brennan himself acknowledged, that's the type of thing that typically is pretty helpful for the jury. It's very helpful for the jury. I am a very thorough note taker, as most of you guys know. Give me one sec here. Here's my notes from the first trial. I got everything all tagged and so forth. But, you know, I deal with lab reports a lot in my work, this type of evidence, very familiar with how this kind of testimony gets presented. And I'm a very detailed note taker. And nevertheless, it it's always very difficult to follow this stuff because the lab will have its own set of numbers. The lab numbers are going to be different from the evidence numbers. How things get referred to will vary throughout the course of the trial. And so being able to keep track of what is not easy. It's not easy at all. Dealt with this in the Richard Allen case, trying to track all these like different DNA samples and which one was which and what was found where and all of that. It can really be a nightmare. So yeah, if you have a way to present all that in a way that ties all those pieces together, that's going to be very helpful. All right. This witness was on day 20, so I'm just going to look up and see. Christina Hanley. Yeah, item numbers 3.2, 3-2, 3-3, 7-1, 2, 7-14, 7-12. Yeah, that's what I said. Different class characteristics. 3-2 had a physical match with 6 pieces from 7-12. Yeah, 7-12, these like all had different amounts. 3-2, clear apparent drinking glass. 3-3, clear apparent glass pieces recovered from the bumper. 7-12, clear apparent glass from the ground. 7-14, clear apparent glass from the road. And so she kind of tested all of these things together. She concluded 3.3, which is the bumper sprinkles, was consistent in composition with 7-14. 7-14 was clear apparent glass in the road. So they could have originated from 7-14 or from another source with the same characteristics. 3-2, the clear apparent drinking glass, also matched 7-12. So not the same one. 7-12 was found on the ground. 3-2 was found on the ground. And 3-3 did not match 3-2. So, I mean, here's my notes, guys. I got these detailed notes of what's what and kind of trying to keep track of it and stuff. I know how to do this. I know what's coming, and I'm deliberately, writing all of this stuff down because I'm a little bit neurotic about that. I know how hard it is to go back and try to recreate it. And even me, it's a little difficult to sort all of that out. I got to have all these different references, and I didn't take note of who discovered what, when. I don't know what the chain of custody of all this stuff is. I don't have a lot of detailed information about these different items. I see 7-12. Okay, 3-3 is 5 pieces of glass. The largest was 7/8 of an inch by 5/16 of an inch. So that's the largest piece of the bumper sprinkle. And the smallest was 3/16 of an inch by 1/8 of an inch. So we got these physical measurements, but we have no weight measurement. At least not that I wrote down. It's all very detailed, difficult to track. Yeah. It's going to be helpful for the jury to be able to make sense of that, particularly if it ties in with the defense theory about what are the bumper sprinkles even doing there? Because all they match is this piece of glass that was found in the road, apparently separately. When? I don't know. But if they match, it kind of seems like that's an important part of the story, doesn't it? Seems like that's probably an important part of the story. Found in the road, doesn't match the tumbler. So what is it? And how did it get there? I think that's what everybody would like to know. But if it goes to the hoax, then of course that's not where the Commonwealth wants us to be focusing our attention. We've got a few comments and questions in here. I'm going to go ahead and take the opportunity to start going through those. Let's see, Ms. Jake with a thanks for all you do. Well, thank you so much. Appreciate you being here with us this morning. Damaris San Giuliano, what do you think about the Commonwealth's motion re the shifty, cozy relationship between the Attorney General and the defense diabolical? Yeah, I mean, you want to talk about propriety and bashing witnesses, smearing witnesses. The projection is just very loud. Very loud. So they haven't, of course, gotten to this motion yet, but I certainly did see this. This is actually the Commonwealth's opposition to the defense's motion to basically present evidence that that ARCA is unbiased. And the Commonwealth is saying, no, they're not really unbiased because we think, I mean, okay, I'm trying to be fair to the Commonwealth's argument. I really am, but it's just so attenuated. The Commonwealth says, we think we have a good faith basis to assert, not once again in an affidavit, but just in a written motion that is argument and not fact. Good faith basis to believe that Karen Reed initiated the federal investigation. She started it. It was because of her. Okay. Maybe it was. Let's say it was. Does that mean Karen Reed has control over the course and conduct of the FBI investigation? Of course it doesn't. Of course it doesn't. They had to get all of this stuff through the same TUI process that the Commonwealth had to get it from. So, you know, implying there's this cozy relationship that she somehow controlled ARCA because somehow she controlled the investigation because the Commonwealth thinks she started it all. It's pretty ridiculous. It really is. It doesn't even establish the point that it's ostensibly in this motion for, which is to establish that she influenced what ARCA did, and therefore they're not biased. You're not even in the universe of establishing that, even if all of this innuendo that you're trying to put out there is true. So I'm going to be interested to see definitely how the defense deals with this motion when we get to it, because it should be coming up. If her method seems to be we're going through all the defense motions first, and then we'll go through the Commonwealth's, then yeah, we should get to it today. I'm going to be interested to see how they respond to that, because I don't think they're going to be real pleased. I don't think they're going to take that sitting down. So we'll see what they have to say about it. That Southern blonde lawyer, Boomer Bev, needs the boot. We know she won't grant defense motion to dismiss, but has she ever even issued the order? P.S. AB's makeup. Oh, well, you are too kind. You know, it's 5 a.m. I got to give myself a little life. No, I mean, of course she won't. We wouldn't be dealing with all of these motions in limine if she was going to grant the defense motion to dismiss. She would simply tell us up front, like she did with the whole candor to the, you know, tribunal issue. She would simply tell us up front, oh, by the way, I'm going to dismiss this case so we can forego all of this argument we're about to have on the details of the case going to trial. So no, she hasn't issued the order. She hasn't done anything with that. She's taken the opportunity to, chastise the defense. When and how and is she going to announce her ruling on the motion to dismiss in a similar fashion? Or is there just going to quietly be a written order that shows up in the docket at some point denying it? I don't know. I'll be interested to see. Ro, good morning. Well, good morning to you too, Ro. Appreciate you being here. San DB. So Scorty Bello is a hack compared to Wolf. Okay, when cross-examining her, the defense can ask her why Commonwealth says she is unqualified to determine the manner of death. Oh. That would be funny, wouldn't it? That would be funny. I mean, it does clearly seem to be their position, you know? What is she? She's a whack. She was one of the whack job cunts, right? That was one of the Trooper Proctor texts. Wasn't she another whack job cunt? Pretty sure she was. Yeah, I am really not getting how Hank Brennan can stand there with a straight face, having filed a motion arguing that the manner of death is irrelevant and prejudicial and should be excluded anyway. While simultaneously, apparently wanting to proffer somebody else, a neurosurgeon, as a witness as to the manner of death. I don't know how you even do that. I really don't. It's these are irreconcilable positions. You don't get to do both. It's not that it's irrelevant because it's hers. If it's relevant for him to testify to, it's relevant for her to testify to. So how on earth do you close this circle? I don't understand. I really don't. How with a straight face he can say it's fine for this neurosurgeon to testify to, but we can't get into it with Scorty Bello. It's irrelevant. It's just so obviously outcome driven. He doesn't like what she said. And he doesn't like what she said because it's exculpatory to the defense. She was a great witness for the defense. She described how she doesn't only take into account what she can see and determine for herself from doing her autopsy. She takes into account information that she gets from law enforcement and their theories and what they provide to her. She kind of vets that, takes it into consideration. Now, of course, like we talked about during the trial, a lot of problems with that. A lot of problems with that. Any forensic expert, ideally, should be black boxed. They should be blind. They should be blinded. You don't get tainted by the other witnesses and by other information. Wonderful book. I just finished reading real recently by Dr. Saul Kassan, Duped. I've mentioned it before. He's a PhD psychologist and has spent his career studying false confessions. One of the very, very interesting chapters in this book talks about the ability of a false confession to taint other evidence, eyewitness evidence, character evidence, and even forensic evidence. People just put so much weight on that particular piece of information in their minds that it shifts their view. It biases them to certain outcomes. So forensic experts should always be blinded. Okay, that's just good science. But they didn't. They didn't in this case. Not how they do things in Massachusetts, apparently. And frankly, For whatever reason, we don't have rules that say scientific experts should be blinded because that's what you need for reliability. That's what you need for them to not be biased. Like, this is not a controversial proposition, but courts have this very, very broad tolerance of bad science in the courtrooms. Not how they do it in Massachusetts. She gets to talk to them about their theories and about their other evidence and so forth and see if it adds up in her mind. And yet, despite having all that information available to her, couldn't confirm it. Couldn't say, yeah, you know what? I think you're right. This is a homicide. She could not say this was the result of a human caused death. Couldn't say it's not accidental. Couldn't say. So yeah, that's really exculpatory to the defense. And that's precisely why Mr. Brennan doesn't want it in. He doesn't want that in. He wants the person who's not responsible for making that determination and who isn't a forensic pathologist to come in and testify to what he thinks. He apparently, if we're to take Mr. Alessi at face value, this neurosurgeon is going to come in and say homicide. This was a homicide. I don't know how we get there. I don't know how we get there. Fall backwards. I buy a fall backwards. I absolutely buy a fall backwards. To me, that makes the most sense for why you have this gash and why you have this severe head injury. You see somebody get knocked down in the ring, UFC, boxing, whatever your combat sport of choice is. The injury isn't the point where they get hit. I mean, it can, you can certainly get your bell rung from contact. It's when you hit the canvas. Wow. Head hits the ground. Yeah, it hits it really, really hard, and your brain rattles around inside your skull. That's always made sense to me as a reason why he's got that big gash on the back of the head and why he's got the brain injuries that he does. It makes perfect sense. But that tells you nothing about how he came to fall backwards. So you don't know if he slipped and fell, on the sidewalk and cracked his skull, which happens. Definitely happens. Black ice. Black ice is very, very, very dangerous. Oh man, I had a bad snowboarding day out at Crystal Mountain once. Crystal Mountain is one of the big mountains in the Cascades. It's over kind of near Tacoma. Only went there a few times, but I went there on, Cascade snow is really not renowned as it is. Cascade cement is is kind of what it's known as. It's just very wet. And so it gets very dense very quickly, it gets compacted and stuff. And so I went on a day where there had not been new powder for probably a couple weeks. It's all old snow, very, very compacted. And I had a moment coming down one of the runs where on my heel side, and you're trying to catch your edge, but with the snowboard you only got the one edge, and so it's easy to lose it, to skip. You don't carve as well, and I admit I don't always do the best at keeping my edges sharp. So anyway, I skidded and brought me right down. Boom. I'm usually pretty good at falling, right? You fall a lot on a snowboard. You learn how to fall, but it just happened so fast. Couldn't stop my head from just smashing into the ground. And I saw stars. I saw stars. That fall rang my bell harder than any hit I've ever taken in the boxing ring. Nobody murdered me. Nobody did that. That wasn't a homicide. I mean, I'm saying if I had died, it just happens. That kind of thing happens sometimes. So I don't know how you get from, okay, maybe he fell backwards, which I don't particularly have a problem with. And I don't even really have a problem with the neurosurgeon testifying to that. I buy that, yeah, he's probably treated a lot of head injuries. He's seen what happens when people slip and fall on the black ice and crack their skulls. So I'd expect he could say, yeah, I've seen a lot of situations like that, and here's what the injury typically is, and this looks like that type of injury. I really don't have a problem with that. Yeah, that does seem within his area of expertise. But yeah, to go from that to it's a homicide, if that's really what he's going to testify to, I'm not seeing it. I'm not seeing it because I don't know how you, as the doctor, are ruling out did he slip and fall. Yeah, the double standard with Scorty Bello and the Commonwealth's Dr. Wolf is quite notable. Lawyer nurse, I'm a trauma expert, and RV, his CV, he is not experienced. I'm assuming this is also talking about the Dr. Wolf, the neurosurgeon. I mean, like I said, he's seen situations where he knows what the cause of the injury is, and he's seen what the injury results. He's not probably an expert in doing that type of reconstruction, like everything else being equal, here's an injury, what caused it. But I don't really have a problem with him relying on, I've seen thousands of these injuries and it looks like this. I mean, that is ultimately the same kind of testimony that Dr. Russell is giving. She's saying, I've seen thousands and thousands and thousands of dog bites. I know what they look like. That on his arm looks like a dog bite. I don't really have a problem with that. But yeah. Why he slipped and fell, maybe fell backwards and hit his head. I definitely have an issue with him going down that road. Lauren Boburn, Brennan can say clearly, defense can't say obviously. Well, and even Judge Canoni can apparently say obviously. But if the defense thinks something is obvious, she's going to take them to task. She's just almost like chronically unwilling to see the defense perspective. She's just unwilling. Of course it's obvious. Of course it's obvious. Because every trial where you have experts, they're going to make that request. Let my expert sit in to watch the other expert's testimony. That's the only way you can effectively respond to it and be prepared to rebut it. Experts get to rebut each other. They get to respond to each other. So no, it's not an entitlement, but is leave routinely granted? Yeah. Yeah, it is. So, I mean, if you want to talk about something that's obvious, that's a pretty good candidate. That's a pretty good candidate. What is not obvious is, are these the same? Are these the same witnesses? How the jury, conduct is going to go, all that stuff. Like, no. I don't think I wrote down where she actually said that because I was too busy responding to it when she said it. Like literally minutes ago, you just told them, don't say it's obvious. It's not obvious. You need to put it in a written objection. But the Commonwealth apparently does not have to put their objections in writing. They get to just stand up and raise them on the fly. American Dreamer, do you think it would have been better for Karen to testify instead of talking to media? Well, not necessarily. She's not cross-examined when she testifies to the media. She's not, confronted. It's not the same. It's not the same game. Not the same context. Of course, the downside is, does her version get in front of the jury? Now, Mr. Brennan, of course, very excited about this. So I'm just hearing new information about the nature of the glass. No, you're not hearing new information about the nature of glass. The nature of glass remains unchanged. It is a silica-based substance that has certain properties that experts are going to be testifying about. Nature of glass hasn't changed. But you may think the theory of glass has changed. I don't know, because Karen didn't testify in the first trial. So we don't know if she's ever had a theory of the glass. Certainly not one that was ever presented. All the defense pointed out in the first trial is that what they found in the yard, the tumbler glass, doesn't match those bumper sprinkles. And that's kind of sus, isn't it? Where did the bumper sprinkles come from? So I am having difficulty seeing how this evidence gets in.
We're back in
Back
session.
up.
Be seated.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very
On
long.
that
I want
one
to
motion.
formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action.
We'll chat about
That
this.
would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing
Accelerated briefing.
for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order.
Interesting.
The decision, that's another question.
All right, thank you very much. Does it
Accelerating
make sense for
briefing.
me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan? Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works, so why don't you tell us?
Sure.
Yeah, since you're her
as
lawyer.
Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which aren't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps
Of course,
unfair to
obviously.
Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Yeah, okay. So the reason why they are bringing this up right now, the reason why Mr. Weinberg told them it was very important to bring it up is because they have to ask her to rule on the continuance before the federal court would consider granting a stay. They are always going to favor letting the trial court handle its own business when it's a state court. I put out a piece on Substack. It's only up there for paid subscribers right now, but I went and talked about the federal stay, and there's just this very difficult position that has to be navigated to even ask about that. And the reason why is because of this abstention doctrine. Federal courts do not want to tell state courts what to do. We have a federalist system of government. They have separate and unique independent interests. And so the federal court typically is not going to say, like, we're more important than you, we can boss you around and stuff like that. It's very much a hands-off approach. But there was an analysis laid out in the district court's ruling denying the habeas petition, where they specifically addressed abstention and they pointed out what the pathway is. She does have a remarkably good pathway because there is a specific congressional statute that allows for a federal court to grant a stay on appeal of a habeas petition. So it's right there in the statute that Congress said you can do that. And that's one of the initial and hardest hurdles to clear if you're going to ask a federal court to go tell a state court what to do. So then it just becomes a question of equitable balancing. Is it fair for the court to do this or not? And the potential harm to Karen if they don't do it, as they're pointing out, it's kind of great. It's a double jeopardy violation. There's a risk that if they do decide in her favor, she has already been subjected, to a new trial. She's had to pay for it. She's had the stress that results from being in that type of situation. You can't take that away just by getting a decision. Mr. Jackson here is pointing out it can interfere with this trial and how this particular trial goes. So she's got a pretty strong case on the equities. And the question is, what is the harm to the
So we'll
Commonwealth?
see everybody back here, not tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will, thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
Oh, so we're having a whole other hearing day, I guess. What? Wait, what? We're just stopping? We're just stopping. I'm going to keep the stream up because I'm confused. I guess we're done. I guess we're not having the rest of the motions.
I got it. Get too close. I don't have to get you.
They're all packing up. I guess I'll keep it back up until they go to the fan. Okay, well, I guess we're done. And now we're going to the fan. Okay, this is weird and chaotic. I guess because it's the Karen Reed case, and I guess that's just what we have come to expect and know. Well, so like I was saying, on this whole issue with the federal stay, it becomes an issue of the equities, the balancing the equities. The harm to Karen is great. The harm to the Commonwealth is not really that much. They're not asking to make the trial go away altogether, right? They're not asking for a ruling. You can't ever try her, not at this point. On a preliminary basis, they're just saying, push this off. It's a hardship, yeah. But on the balance, does that outweigh the fact that if Karen Reed wins her case, she's not getting she's not getting an effective remedy? So it's a much stronger case for a stay than I had originally thought it was going to be when I kind of sat and looked at this. I still think it's unlikely, and I'll tell you why. It's because typically in this sort of equitable context, one of the things that's taken into consideration is what is the likelihood of this happening? What's the likelihood that you're going to experience this harm? If you do experience it, yeah, it's bad. We can establish that the magnitude is bad. But they're not going to take that in a vacuum. They're going to look at, well, is it likely to happen? And so to make that determination, they kind of preview the merits of the case and they look at, well, do we think she's likely to win? So usually a great example of where this type of standard is often applied is with a temporary restraining order. If you want to go get a temporary restraining order in the federal court, one of the things you have to show, you have a substantial likelihood that you're going to win on the merits when this thing is actually fully heard and fleshed out. You are very much on the winning side. You're on the front foot. It's not definitive, of course. Sometimes it happens that a TRO is issued, and then you have the full hearing, and you don't get the permanent relief. But you at least are able at this stage to make a pretty compelling point that that you're going to win when this is all said and done. And that's where I think Karen has a harder chance of being able to make that showing. She got the certificate of appealability from the district court, which is definitely not nothing. That's a finding that basically reasonable judges could differ on this issue. It's a serious enough issue that this warrants greater attention. It is not a frivolous claim that she's raising. But that's pretty different from, she's likely to win it. And from the double jeopardy side anyway, the big impediment that she has is that Bluford decision. Just, not that old from the U.S. Supreme Court. Not quite factually on point, but dealing with a pretty similar situation and holding that the trial court doesn't have a duty to ask for partial verdicts. Just don't have that duty. So she would really have to show that was either clearly inapplicable under the facts as they're presented in her case, or that there's a really good reason why Bluford either is wrong or why if it doesn't apply there should be a very different rule applied in these particular settings. So interestingly, I think I keep coming back to, I was very interested reading the habeas decision, because my personal problem with this whole framework, she is legally on the back foot. I've gone over that a few times. But part of the difficulty I have with that is because what constitutes a verdict should not be something that just the state gets to decide. The state passes a law that says, well, only if the jurors come in and do it in open court, only if the jurors come in and use these specific words, only if, this, only if that. And that's where it seems to me that there's kind of room to work with that, with how can you possibly have the scope of a constitutional right decided by a state legislature? And as it turns out, my instinct, I think, was on, because that's not the law. The the district court opinion made it very clear that what constitutes a verdict for something for purposes of double jeopardy is something that the federal courts get to decide, not something that is defined as a matter of state law. So that's where personally I feel like, that's the weak spot in this whole point. Because if the jurors did in fact make that decision, it seems that it should be the decision that is dispositive and not how they express that. Because otherwise you can just put all kinds of limitations on how they express that, and what's the constitutional one? What's the constitutional way of declaring a verdict? Well, they're telling us it's being returned in open court. Is that right? I don't know that that's right. I really don't. And part of the problem is because the way that the returning of the verdict works as just a procedural matter, the jury foreperson has so much control over that, because they're the only one that gets to communicate directly with the judge. They're the intermediary between what's going on in the jury room and what is communicated back to the court. And ultimately, like what is done in terms of formalizing decisions that the jury's made. But that's basically that's the sticking point. That's the uphill battle that she faces. So because of that, showing that she is probably going to win the appeal, that's going to be a tough call. It's going to be tough to do that. That's why I think the federal court is going to be probably reluctant to grant a stay. However, they're not likely to consider it at all if they haven't at least asked Judge Cannoni herself to do that first. It's way less. It just takes it off their plate if she's willing to go ahead and show the same kind of respect for their process that they are showing for hers. well, then, then they don't have to worry about it. But if she wants to be, gung ho ahead, we've got it scheduled for April the 1st. We've got all the jurors coming in and so on and so forth. Is the federal court going to come in and say, you gotta wait anyway? I mean, they might. I can't say they won't. I can't say they won't. Not after seeing, kind of what the legal pathway is. I can't say they won't. I do think it's unlikely. But yeah, they could think this is a serious enough potential consequence. The fact that they've accelerated the briefing schedule is really significant because, yeah, it does increase the possibility that there's going to be a decision in the middle of the trial. Maybe not likely. It's a very, very fast time frame for federal courts to get things done. But they did accelerate it at the district court level. That said, still took months. Still took months, and that's pretty routine. That's pretty routine. Appellate courts measure things in months, not in days, not in weeks, in months. So we got an estimate, a length estimate for trial, 5 to 6 weeks total. Starting April 1st. So that means first, second week, second, third week in May, thereabouts, middle of May. If this is getting briefed right now, we're talking, 2 months for the Court of Appeals to decide. It seems unlikely to me. Not impossible. Definitely not impossible. And especially if they're already on notice because of the stay motion that this is still going on below, and the court's not going to want to continue it if she doesn't. But I am intrigued by this sudden ending of the day. And I mean, are we coming back tomorrow now? I don't know. We were originally scheduled to come back tomorrow, but now she said Thursday. So maybe we're coming back Thursday and not tomorrow. Maybe we're coming back both days. I don't know. I'm just going to kind of keep my eyes on what people are able to figure out over the course of the day today. I will be here when they get back to it. But I'm intrigued by it because you have taken away a lot of your preparation for trial time by getting rid of more than half a day today. Now, maybe we made enough progress through the motions that she's decided for herself, we can wait and see how things unfold in the federal court, come back on Thursday, deal with whether we're going to continue the trial or not. And then if we're not going to continue the trial, we would still have enough time remaining on Thursday to be able to get through all of these remaining motions. Maybe that's her thought process, but boy, is that really foot on the gas. And some of these motions are pretty significant. We're still dealing with the third-party culprit stuff. We're still dealing with Morrissey and Nelson, the John O'Keefe stuff, the Commonwealth's motion to exclude bad character and misconduct evidence. This was a motion. I don't even know what they were asking for. I really don't. It was a rant. It was not a motion. It was a rant. This motion just basically says she's made accusations against anyone and everyone, and they've flown around, and it shouldn't be allowed unless there's prior approval granted. This is a stupid motion because it's not tailored at anything. The judge should not, and I would expect, would not rule that the defense doesn't get to challenge the prosecution witnesses. So what do you think constitutes an accusation of misconduct? Well, if they change their testimony from, say, when they testified at a grand jury proceeding versus when they testified in court, maybe between when they testified in court last time versus when they testified in court this time, You get to ask them, were you lying under oath then, or are you lying under oath now? Is that accusing them of misconduct? Yeah, it kind of is. And it's allowed because that's impeachment. So it's ridiculous in that it's the kind of motion that is just basically asking that the defense have to follow the rules of evidence. And that's pointless. It's pointless. The reason to bring motions in limine is not to remind people that there are court rules that they have to follow. It's to challenge specific pieces of evidence. So if there is something specific you want them not to be able to say, if there is a specific accusation you want them to not be able to make, that's what a motion in limine is for. But you need to identify what it is, and then you need to provide your argument for why they shouldn't be allowed to do that. So, a little bit of a tangent there. Sorry about that, but it's still out there. You know, one of the motions. The Commonwealth's motion to prohibit the IA, the sustained findings against law enforcement witnesses. Yeah, that's kind of significant. I don't know what their possible basis is to think that the witnesses can't be impeached with the sustained finding of misconduct as it pertains to this exact investigation. That's pretty relevant to a Bowden defense. Oh, the whole issue of the lack of bias of ARCA, that's going to take some time. The whole prohibiting juror contact by the district attorney and the MSP, that one's impounded based on the June 25th sidebar and some text messages that include Trooper Fanning and Trooper Proctor. Don't know exactly what that is, but it sounds like the type of thing that might take a little time. Might be a little bit juicy. So, a lot to still go through, and not necessarily leaving a big window to be able to do that if we're still going to get started on April 1st. So it does make me wonder, are we back now? Are we back now in the possibility of this not going forward on April the 1st? Kind of seems like we are. Or we wouldn't have taken the rest of the day off today. We would have just gone ahead and continued to work through these. And hopefully it's not moot, but if it is, we've dealt with it. And when and if the trial occurs down the road, if there's been a change in circumstances, we can deal with it then. But otherwise, we've just taken some of these preliminary things off of the table. I think she might be considering a continuance. No way to know, but that's what this action signals to me. Well, I guess I see in the notes here that she's delayed until Thursday because she wants the attorneys to give more details about the timeline and deadlines for the federal appeal. The appellate lawyer, Caleb Schillinger, said he would need to talk to people in order to get more clarity about the timeline. I mean, okay, but it doesn't overcome the problem that we already have, which is it's up to the court. And the court is, I would be shocked. I would be shocked if the court says, yes, I'll handcuff myself to a specific timeline. They don't do that. It's not likely to happen. There's just too many things that can come up that is too contrary to the culture of the appellate courts. It's just not how they operate. So I'd be shocked if talking to anybody is going to sort out when is the First Circuit going to make a decision. But maybe it will. Maybe it will. I did find it highly amusing that there was quite a bit of confusion about Mr. Schillinger's actual status. Is he a Commonwealth lawyer or is he not a Commonwealth lawyer? Yeah, that's a little bit confusing because on record over there in the federal courts, he's the court's lawyer. That's who he's representing. He's representing the courts. He's a special assistant attorney general who's been appointed, despite the fact that he's a Commonwealth attorney. So there's a little bit of a problem from my standpoint. I have a hard time seeing how it's not an appearance of partiality to be represented. The court is being represented by one of the parties before her on this case. Brought this up a while ago. Nobody's raised it, nobody's challenged it. Maybe it's nothing. To me, that looks really weird. And no, this is not just a peculiarity of habeas law. It has nothing to do with the habeas process other than just that's the context where this representation is coming up. It has to do with the appearance of partiality to be represented by a lawyer who works for one of the parties. I don't know how this is not a problem. So I'm highly entertained by the fact that Judge Cannoni doesn't seem to know the guy you're talking to right now is representing you, the court, representing the court. You're the one who is going to be subject to whatever the Second Circuit decides. If the Second Circuit decides there needs to be a writ of habeas corpus issued, you're going to be the one responsible for carrying it out. And if you don't, you're going to be the one that potentially gets the enforcement action. So this is your lawyer. But confused about, representing the Commonwealth. He's advocating the Commonwealth's position, at least to some extent. He did do a good job of saying neutral. He just, he didn't say, I don't want to move the trial. He did kind of concede if it's possible to resolve the federal stuff, that's going to be better. But of course, obviously, the Commonwealth is opposed to moving the trial. I don't know why it's obvious. Why is that obvious? That is not as obvious as the expert witness sitting in on the other expert witness's testimony. Am I surprised? Of course not. Of course I'm not surprised. They want to get their pound of flesh. We all know the Commonwealth wants to get their pound of flesh. Oh, but I did find that amusing. Yeah, I understand why it's difficult for you to keep track of who this guy represents under the circumstances as they are presented here. So they have to file the motion to stay with the district court before it goes up to the circuit court. That's a factor of the federal rules and how the federal rules kind of require stay requests to be presented. So they'll ask him, and if he'll want what he wants or doesn't want. He'll defer to the court or not defer to the court. I don't know. We'll see. So with that, let's go ahead. I left this up because I did just kind of want to finish my thought about this. We were talking about this right before the last session came back up. The fact that, like Brennan is arguing, the nature of the glass has changed. It's not. It's still silica. But whatever he thinks the defense thinks about the glass may have evolved. And that's fine because the defense never went on record in the first trial with any sort of theory about the glass. And it's not their duty to do that. They don't have to have a theory about the glass. So he's just saying he got new information from Karen from the documentary that aired last night, which I haven't watched yet, by the way. Got new information about the glass from that. So I was talking about, is that going to be admissible? It's a little bit tricky to see how without calling somebody from the production. And the reason why I say that is because Normally, if you have an out of court statement, the witnesses, the defendant's out of court statements are typically always going to be admissible. They're counted as admissions. They're statements, that she's making about the incident. Some places are a little bit narrower about it has to actually be something against their interests, and they do that to, well, sort of limit the ability to put on evidence of the defense things that the defendant has said that are exonerating. Like it lets them go in and cherry pick just the stuff that looks bad. But it appears that the Commonwealth will typically be able to bring in really anything that she said. But normally, the way that you do that, it's because it's going to be in the context of most commonly police interrogation. Sometimes it'll be like we saw at the last trial. She said it to a witness at the scene. And so it's somebody who was there, who heard the statement, who received the statement, that's testifying about it. So how could they overcome that? Well, what I would expect they might try is to have somebody like Buchanan testify, I watched this program and I saw her say these things. But the problem is the program is also a level of hearsay. It's its own out of court statement, and it's reflecting hearsay statements that Karen made. So the program itself is not necessarily going to be admissible. And part of the reason why, you weren't there to hear for yourself what she said. You are taking that secondhand from a producer, and you don't know what the full context was. You don't know if this is raw and uncut. You don't know if this has been edited. You don't know if it's been modified. You don't know anything firsthand about these statements having been made. So I think they would need somebody who was there if they're going to be able to get that in. If the trial gets delayed, maybe they'll pursue that. Maybe they would have the time to do it. But just trying to get something like Trooper Buchanan in to testify, I watched it on TV and here's what she said. I don't think that clears the hurdle, because it clears one hearsay hurdle. She said it, but not the second. It was reported in this TV program that is also hearsay. So in that sense, getting back to the question here, would it have been better for Karen to testify instead of talking to the media? The media has given her the opportunity to be able to put her story out in a way where, it's not guaranteed that they're not going to challenge her, that they're not going to confront her, and they're not going to be subject to the kinds of rules of evidence that a prosecutor in court is going to be subject to. So maybe this will be a tough interview. I don't know. Haven't watched it. But I guess I'd be surprised. And even if it is, like, most journalists are just not going to have the same kind of skill at confronting a witness as an attorney who's done it, dozens, hundreds, maybe thousands of times in a trial setting. So it really just depends, I think, on how much she wants the jury to hear this. She's got potentially a kind of realm of what she wants the public to know, and a realm of what she wants to be available at trial. If she wants the jury to hear this at trial, the only way that she's likely going to be able to get it in is for her to testify. I've said so many times, I know, I am not the majority position among defense lawyers, but I always want my client to testify if that's going to be possible. I always want it. The jury wants it. They're going to be instructed they can't consider if she doesn't, but they still will. they still will consider that. That was another thing that came up in the Duped book I was talking about, Dr. Cassin's book. Talks about that. The jury being instructed to disregard things. Lots of studies on that. Can they do it? No. He's looking at the question of, well, is Miranda really a protection against, police interrogation and the types of techniques that they use? Well, if you could freely invoke your Miranda rights and not have any consequences from it, that would certainly help. But yeah, study after study after study shows jurors can't put it out of their minds. They will hold it against you, even when they're instructed that they're not supposed to. So I would like to see her testify. I really would. And she is an intelligent woman. She is an articulate woman. I think that this idea that she is like somehow unlikable or that she's going to come off badly to the jury, I'm very skeptical of that, having put some very unlikable people on the stand over the course of a trial career as a public defender. I'm just very skeptical of that. I think she can be prepped for the type of challenge that she's going to get, the sort of tricks that are played with the questioning. And the real issue with that, it's not about it's really not about coming up with the right answer. It's just about not being reactive, not letting yourself get angry, not letting yourself get emotional, um, not letting yourself get combative. Okay. If you want an example of what doesn't make you look very likable when you're being challenged, go back and watch Jen McCabe's cross-examination, because she just gets very combative and very slippery and very self-righteous. And it does not make her come across as likable. So that's really what you want to avoid. And those are technique issues. That's not substance. That's not, coaching a witness on the substance. You're not allowed to do that. But you can, you can absolutely work with her to be prepared for that kind of challenge and how to deal with it. All right, that's a lot of time on that question. Very good question. Thank you for bringing that up. Duncan, Idaho. Brennan is actually physically incapable of making or responding to emotion without some sort of exaggerated emotional overture. He would suffer some horrible pain if he tried to resist it. He does have his bag of tricks, doesn't he? That he just keeps pulling into the Ipsy Dixit, the Ipsy Dixit. He said it, he said it, therefore it's true. Doesn't have to be founded. Doesn't have to be substantiated. He says it. He says there's absolutely no evidence. We've seen the evidence. I remember this is what I talked about when they were in that motion to exclude Mr. Green. And he kept saying absolutely no methodology. Well, no, he has stated a methodology. You may not think it's a good methodology. You may not think it's a sufficient methodology. But you haven't given us any reason to make that conclusion. You haven't given us, something, for example, from one of your own experts explaining what is the correct methodology. Just kept saying absolutely no method. Well, it's right there. Like we can read it for ourselves. So the Ipsy Dixit is a big one. The absolutes are a big one. Certainly it's clear. If it's clear, you don't have to tell us it's clear. You can simply show us and we will see for ourselves because it's clear. When you tell me it's clear, you're telling me it's not clear because you could just show me. You could just show me if it was clear. Absolutely no evidence. I mean, all of these definitives. And then yes, of course, the emotional plays. The emotional plays. I wouldn't mind seeing the defense address this in a motion. I really wouldn't. And I just got done saying, don't like these motions in limine that are just reminding us of what the rules of procedure and the rules of evidence are. They need to be specific. And so I would not counsel a motion that's just like generally, hey, Mr. Brennan tends to say these inflammatory things to appeal to the passions and prejudices of the audience, the court, and when the jury is there, the jury. And we'd like him to not do that because the rules don't allow it. I would, however, suggest potentially pointing out specific things he has said that are inflammatory, that are unfounded, and that reflect this strategy that he uses of being very emotional. Point them out and say, we would like him to not be able to do things like this, not say things like this while the jury is present because it's improper. And if he does do it, I hope that they're on it. I really do. Hope that they're on it. I hope they object to that. I hope they make their record. Because yeah, inflammatory stuff that can add up to misconduct. It's actually one of the better ways to be able to show it. A lot of cases on juror misconduct or on prosecutorial misconduct have to do with prosecutors getting a little too into their emotions, letting it carry them, and takes them too far, and they cross the line. One of the big cases in Washington that we like to cite when it comes to prosecutorial misconduct. Don't remember the name specifically off the top of my head now, but he was the prosecutor is so angry, at the defendant who is a member of the American Indian movement. This is back in the day. AIM I think still exists, but I don't think that they are really prominent anymore. A member of the American Indian movement, and the prosecutor is so angry at him. He's a member of this organization that's a bunch of indiscriminate butchers and madmen, just this outrageous, inflammatory stuff based on an association. You have a right of association. And so that's one that got thrown out. You got to retry the guy. You don't get to poison the well like that. So he needs to watch it for his own benefit. And it's not a good habit to have, not for a prosecutor. Duncan, Idaho, I think Karen Reed's team watches you and Melanie Little. Well, I would certainly be honored if they did. Call me, email me, whatever. We can chat. That Southern blonde lawyer, Ipsy Dixit, drinking phrase for trial. Oh, I don't know that Ipsy Dixit will come out much. I was about ready to have an obviously drinking game if during attorney arguments we're not allowed to say things are obvious. But I'm sure we'll forget about that rule. The next time. The next time it's inconvenient to remember that. Ipsy Dixit, it's a great turn of phrase. It really does characterize so much of how the Commonwealth presents its argument. But it's probably not going to be said a lot in front of the jury because you can't explain it, and you don't use Latin for a jury. It's not going to connect. But I was very excited to hear that, Mr. Alessi. Anti-Deb's Judicial Bench Award. Touch DNA glass from the last car on the transport trailer. Flew on the bumper. Solved. Methodology assistance by Hank. Oh man, if they suddenly found John's DNA on the bumper glass, that would be a whole new level of shenanigans. Yeah, there's a reason why Mr. Brennan doesn't want a clear picture of the bumper glass. There's a reason why. Duncan, Idaho. Andrea, have you ever watched sumo wrestling? I recently got into it and it's amazing. The March tournament is halfway done now in Osaka. Give it a try. Well, oh, okay. I'm willing. I'll check it out. I have not like watched sumo wrestling per se. I've not followed sumo wrestling. I have, of course, seen it, and I've watched a couple documentaries about it. There was a documentary. Once again, can't remember what channel it was on. But I want to say I saw it a couple years ago. But it was about like sumo wrestlers in training. They all kind of live together in the same house. They're all trying to advance, and it was just kind of about the culture of the sport, the training, and really what they go through. Like the sport is one, I think, like many that has, like football, for example, the physique of a football player has changed a lot in the last 50, 60 years, whatever. And sumo is the same. It's always been a sport, for large men. But like it's reached the point now where the weight is kind of reaching unhealthy proportions, and that's one of the things that they were looking at in this documentary is like the diet and stuff, what these guys eat during their training, and the fact that if they don't make it in sumo, they have to leave and go on and do something else. That can have significant health consequences and stuff. So anyway, that's just one thing I remember seeing. I don't know a whole lot about the rules other than I believe it's pretty similar to like American wrestling where you have a line essentially and you have to try to it's not pin the other guy in sumo. I'm pretty sure it's like get the guy over the line. In wrestling, like you're not supposed to leave the line. You're supposed to supposed to get a pin. And if you leave the line, it's like it's you've lost, disqualification. So sumo, it's just that part. Just get the other guy off the line, I think. But I'll give it a shot. I mean, I'm interested in it. I'm kind of interested in things like that. Duncan, Idaho. The cause of death was an argument Karen Reed had with John O'Keefe earlier that month. She yelled at him, and it caused him to fall and have a dog bite him. Yeah. Yeah. I mean, I don't know where we get to. I don't know where we get to manner of death. I'm willing to concede. Yeah, fall backwards sounds like a very plausible mechanism to me. It sounds like a very plausible mechanism. I don't have a problem with a somebody who understands head injuries talking about that. But to elevate that to homicide is something else entirely. But yeah, we have seen the Commonwealth kind of reaching for motive and proof of intent. I do have to wonder where we're going to end up with the key cycles this time, right? The whole justification, as far as I could tell, the first trial for why we are trying this as an intentional murder is because they have this theory that she sped up backwardly up to 28 miles an hour and hit him. And they got that from the key cycles. But then in real time, as we watch the trial, we kind of watch the key cycle theory sort of fall apart. Because if you count them back, when you know the number of times that the Commonwealth has turned this car on and off since they seized it, doesn't add up. Doesn't add up. You don't get the right one. So we know that there are much, more expert witnesses this time. Maybe we're going to have a defense witness that's going to talk about the key cycles. I don't know. But so if the key cycles are out of the table, or they're likely to be discredited, then what is the Commonwealth left with to try to prove intentional murder? Well, they're going to have to reach for something like this. really are going to have to try to reach for, explosive anger for some reason that despite not having spilled over even to the level of like an assault that has intervention, that anybody's witnessed. As far as I know, there's been an agreement, a universal agreement that there was no violence in their relationship. Nobody ever witnessed anything like that. So they're trying to kind of create this abuse dynamic that, from my perspective, when I read the text messages between Karen and John, I see one that is trying to be conciliatory, and I see one that is not. I see one that is tending to be a little bit more dismissive and degrading towards the other. And it ain't Karen. It ain't Karen being abusive. That's what I saw from the text messages. But they're going to have to, they're going to have to try to blow it up into something that out of nowhere, somebody who has no history of violence in her own record, no history of violence that anybody observed with John O'Keefe, despite him apparently telling other people about the relationship, complaining about it, etc. Violence was never an issue. Out of nowhere, she developed the kind of explosive anger that would lead her to kill him. Seems like a stretch to me, but that's why I suspect they're doing it. I think that the key cycles are falling apart, so they have to have something else. Skyway, you and Steve Leto are my favorites. Well, thank you. I appreciate that. Duncan, Idaho, I would really hate sitting in the defendant's seat and having to endure Bald O'Keefe staring daggers at me all day, every day. The fact that Karen has been able to not react to that, to me, bodes really well for the prospect of Karen being able to not react to being needled in a cross-examination. Because yeah, he's like right there. It's like right there next to her. And Mr. Yannetti, I notice, is still in the position that he was in during the last trial. He sits on that end of the table, so he is a shield between Karen and that side of the courtroom where John O'Keefe's family members sit. Very chivalrous move on Mr. Yannetti's part to do that. So give her a little bit of space and a little bit of distance from that. Yeah, I mean, I would probably be annoyed too, but I think she's doing a really good job of not showing it, and because of that, like I said, I think that bodes well for her ability to not be emotionally reactive should she decide she's going to take the stand. Skyway, Karen Reed needs to move far away as possible if exonerated. Yeah, unfortunately, she probably does. And I hate to say it, but it's advice I often give people, in people who have had whatever type of encounter with the criminal justice system. A lot of times, best way out is to just get yourself a new environment, because you're going to be shoehorned in this one. They already have you in a box. And once they've put you in that box, your ability to get out of that box, very, very, very difficult. One of the things that I think was really fascinating to observe about the last trial really was how much open and loud support there does seem to be for Karen locally, or at least locally enough among people who can show up to protest and things like that. I'm sure there's a lot of people from out of the area as well, but it's just more of an undertaking. We saw similar type of environment in Delphi where, yeah, you'd have people that showed up from different places. But by and large, the people who were regulars, the people who were just kind of wanting their presence to make a statement, those were local people. Those are people from that area or close to that area. So it does impress me how much support she seems to have. Um, Now I don't know. I'm not there. I don't know what the mood is. I know that generally, leading up to trial, part of the idea was that everybody is afraid of the McAlberts. They have so much power in this town. They control this town. They have the ability to bully people and interfere with their jobs and things like that. Jill McDaniels will apparently, assault people on the sidewalk and in bars and stuff, allegedly. Uh, so the fact that that seems to be changing, I think the trial gave people permission to be more open in their support of Karen. I do wonder if that's changing a little bit the mood and the dynamic in the community. Um, to where, say, Karen is exonerated and Karen goes out for dinner and people recognize her. Is that going to be a good thing? Is that going to be if she runs into just a random member of the public who is familiar with the case, are the odds that that person is going to support her or be against her? I think before the first trial, I would say, I don't know. But after this trial, kind of seems like her support is pretty high. I know I've read about some local polls and things like that that suggest, uh, the support for the Commonwealth's theory is quite low. Most people are at least not guilty, if not innocent. Distinction between did they prove it and did she actually not do it? So, if she's a hero locally, maybe she can stick around. But there's definitely a risk. Definitely a risk she has to be concerned about. That said, she's already facing that risk, just by being there while this is going on. I mean, the reality is for something to happen to Karen, might not be a bad outcome for the Commonwealth, you know? Limits the exposure of the hoax. There's a risk. There's absolutely a risk. Blessed Mom from Texas. Hey, beautiful. If jury members would have put not guilty on 1 and 3, could Bev accepted that, or is there a rule? No, there is no rule that says she can't accept it. And if they had filled those verdict forms out for the verdict form for count 1 and the verdict form for count 3, and if they had checked the not guilty box, pretty good argument she's required to accept that because she told them that's how to do it. And so this is not a situation where we're talking about a partial verdict on just one count. There were some, like count 2 had a number of lesser included offenses. And so that verdict form had different options. If you start with the voluntary manslaughter, and if you don't, if you acquit her on that, then you move on to the next one. And then if you acquit her on that, you move on to the next one. Much more leeway when it comes to accepting a partial verdict like that. Like if they said, she's not guilty on the first and we're not sure about the second, but we're pretty sure she did the third. Much, much murkier from a legal standpoint about what you actually do with that. But yeah, they're supposed to consider each count independently. And they are allowed to return separate verdicts for separate counts. They're really literally supposed to. Like their decision on one is not supposed to drive their decision on another. So if they had filled out those verdict forms on count 1 and count 3 and they had put not guilty, that's an acquittal. And if Judge Canoni had not accepted that in open court for some reason, then yeah, I think you're in a much stronger footing that this constituted an acquittal. Got a few new members here. Sherry D is a new member. Welcome. And Pro Gamer is a new member. Welcome as well. Tomato Berry, can the defense appeal the finding of misconduct? Yeah, they can. Now, can they appeal it on an interlocutory basis? Probably not, meaning like right now before the whole case is over. But the reality is they don't necessarily have a reason to, because nothing happened because of it. Nothing happened because of it. Now, I'll tell you a reason why I could consider that they might want to, is because Judge Canoni could do something like refer it to the bar authorities. You know, I made a finding of an ethical violation, a lack of candor to the tribunal. And so if her finding would be considered dispositive or even just heavily influential in that particular context, then yeah, they might want to appeal it so that they don't run into ethical problems. So flagrant material, it's just, doesn't it seem a bit much? Doesn't it seem a bit much? There's just you know, just really no grace to the defense team when so much grace is being given to the Commonwealth. Lola the good dog, is there any way to confirm if federal case is actually closed? We have no receipts this call happened, just Hank's and Rafferty's word. Feds confirmed case was ongoing before to defense before. Any ideas? No, we don't. We, the members of the public, very unlikely to be able to get any kind of information from the feds. You can make a public records request if you want. At least in theory, the investigative exemption, the one that applies when revealing information would jeopardize an ongoing criminal investigation. If your criminal investigation is closed and it's not ongoing, then that one no longer applies. But that said, there's typically going to be other ones that they'll invoke. There'll be confidential things and stuff like that. But you can try. But I agree. This is it's very questionable. It's very questionable. I don't know. I don't know why the defense wouldn't have been notified, and I don't know why there wouldn't have been. Just if you're going to release it in a way that is going, that this means it's going to be public. I mean, his whole point when he made the statement was, I'm allowed to say. Why is he the spokesperson? That to me just seems odd. The Department of Justice can speak for itself. They often do. They release press releases. They can do that. And so this whole, well, it's not their practice to confirm or deny the existence of ongoing investigations. Number one, we already know that there's an investigation. That's not a secret. And number two, you're already going against that policy by having these conversations, allegedly, with Mr. Brennan and Ms. Rafferty. So why would you not just speak for yourself? I remain skeptical of that, and that's my reasons for that. Lawyer nurse, red flag. All his career research is MIN, invasive radiotherapy, not acute head injuries. He co-authored 102 papers and authored one book, RV. I did 2 days of research. I mean, a surgeon, I do have a hard time seeing how a surgeon is really the best option for this type of testimony. I mean, you can correct me if I'm wrong, but I don't think the surgeon is usually the one that's doing the diagnosis anyway, right? Isn't somebody else typically doing the diagnosis and they're prescribing the treatment? And then that's when it gets referred to the surgeon. The surgeon is the guy that does the treatment. He's not the guy that decides. I mean, maybe he is. He's probably got input into like what surgery is needed. I don't know. I mean, I'm not in the medical field. I don't necessarily know exactly where the scope of each practitioner's practice is defined. But yeah, it was very clear that his actual work as a doctor is really focused on this radiotherapy. So when Mr. Brennan is saying he's treated head and spinal injuries, he's seen thousands, tens of thousands of patients with head injuries. Uh I'm not convinced that makes him an expert on the cause of the injury, but I am willing to buy he's probably seen a lot of heads hitting the ground. I'm willing to buy that. Uh I don't necessarily think a doctor has to publish, especially somebody who's a clinician. I think it's not that clinicians don't have a research practice, but it's just, a research doctor tends to be a little bit different than a clinician. It's kind of like the difference between an appellate lawyer and a trial one. You're in the trenches versus you're writing about it. Um, so I'm not in any position to really be able to evaluate, the scope of his expertise and where it ends and so forth. My gut feeling, like I've said, if he's seen a lot of head injuries, I don't really have a problem with him testifying about what he knows from that experience. Experience is a way to qualify somebody as well. Um, but it just depends specifically on what he's trying to say, and that's where it's not really that clear to me. I haven't seen the actual motion. This is one that this one came in a while ago. I mean, I did see it, but it's been a while, so I don't have it clearly on the top of my head exactly what his opinion is, and that's to me what seems to be dispositive. Um, I would think he can testify about some things, but it just depends on how far afield are they going to try to take him. Shouldn't be testifying about dog bites for sure. Um, you know, speculating about other injuries and stuff. If we're just going to talk about the brain and maybe the gash on the back of the head, I could see that being okay. But I don't know. I do have to defer to a lot of you guys who know more from your experience in the medical field about where these lines are drawn. Lena B, thank you for doing this. I learned so much from you. Please get your older pup and other animals a special treat from me. Well, thank you so much. The older pup is not with me right now. He is elsewhere. I have the younger pup with me here today, but that is very kind of you. The older pup, uh, I've mentioned, is not at his best. He is unfortunately, at nearing the end of his time with us. And so we are hoping that he will still, have a good summer left, and he's not going to be in a lot of pain or anything like that. But we do need to give the old man a little bit of special attention, and then of course the young dog who's never been without him and really looks up to him and stuff. They're all going to need a little bit of extra support. So thank you very much for that, Lena. Sentient Dreamer, thank you for showing up like you do in this trial. Forgive me if this has been addressed already. Would it be possible to adjust the difference between the court volume and your mic volume moving forward? My old ears will love it. Yes, I do my best to try to adjust this. I often have to do it on the fly. And the reason why is because we get varying degrees of sound quality from the court. Today we ended up settling on the what's the channel, NBC 25, NBC 15. I can't remember, Boston 25, because it seemed to have the best sound compared to the other channels. But that is always a little bit of an issue. And then my also, just so you know, my mic settings had like reset from where I usually have them. So I had to go in and fix that and adjust the volume. But I hope we found a fairly decent balance with that today. We do make that effort to do that. So yes, feel free to let me know or let the chat know, and Jeff can also try to tweak things behind the scene, or let me know if there's an issue with the discrepancy. We do our best. Sometimes we can't. I'll just tell you straight out. Like, we had big problems with sound quality in the last trial from that courtroom feed. It's unfortunately a garbage in, garbage out kind of scenario from that standpoint. So I can try to minimize the distinction, but I also don't want to be so low you can't hear me just because court is so low that you can't hear me. But we'll work on it. We'll try to find the best balance. Cam, the problem is that she's prejudiced just because she's in that chair. Jurors will automatically want to attach any speculative theories bad to her. Napui eliciting false testimony without correcting. We're talking, I assume, about Karen. About Karen. I don't know that I agree with that. Honestly, I really don't. I think a lot just depends on the jury that you get. My personal experience, like I've said, take it for what it's worth. It's certainly not universal, and it may or may not apply to Karen. But I've found jurors to be very, very forgiving of some very idiosyncratic characters, and some bad backgrounds, some bad allegations. My experience is most jurors really want to give everybody the benefit of the doubt. They don't want to think that people are lying. It's hard to convince jurors that a witness is lying, that a police officer is lying. Like, you got to have it pretty rock solid if you're going to go down that road. They want to give everybody the benefit of the doubt, and at least in my experience, they extend that to the defendant as well. And that's one of the good reasons for putting her on, is because if she's not up there giving her version, letting them get to know her, it's harder to do that. And I think it just really depends. It really depends on the jury that you get, and that's where it just comes down to selection. They have to try to do what they can to get rid of those people who are automatically suspicious or automatically accusatory, the j'accuse people. I always think of those like j'accuse. Some people are very, very comfortable accusing other people of things. Some people are not. Some people are give everyone the benefit of the doubt, give people a chance to explain, want to think the best of people. Some people want to think the worst of people. You got to try to get those keep the worst, see the worst in people off of the jury. Because if you get them, then yeah, I think this, they're going to apply that to her. She's the defendant, and she's the easiest one to have the kind of negative impressions about. Napui is a case that applies specifically to prosecuting attorneys. If this is about eliciting false testimony, if that were to happen, NAPOE is not the issue. It's an ethical issue for defense attorneys, not something that that goes to the fundamental due process and the fairness of the trial and so forth. The state doesn't have a right to appeal. Generally, very limited circumstances where that's okay. But yes, of course, if they think Karen's going to lie, they can't put her on the stand. I got to tell you, it's not a high bar. That's not a high bar because, I mean, let's hold this up to some of the Commonwealth's witnesses. Trooper Proctor, we just talked about, subject of this new motion in limine, makes all of these false statements on the stand about this meeting between David Yannetti and Lucky Loughran over there at the Canton Elementary School. Mr. Lally elicited all that. When did Mr. Lally get that police report? I don't know, but that's a pretty serious question in my mind. Because if he knew, what was in that police report and the fact that what Trooper Proctor was saying doesn't line up with it, then that's a decent NAPOE claim there. He elicited it, it's false, it's material because Trooper Proctor's credibility is a pretty significant issue in this case. His ability to be honest about law enforcement actions and activities and what the people he's investigating and their representatives and stuff are doing, it's pretty significant. However, here's the wiggle room. Here's the wiggle room. What sort of, if any, explanation might Trooper Proctor give for why he thought this? Well, maybe his sister told him that's what happened. Let's just say, hypothetically, Mr. Lally asks Trooper Proctor, how do you know this? And he says, oh, this is what my sister told me. Well, now does Lally know it's a lie? No, he doesn't. It's possible that Courtney Proctor told him that. And that, he believed it. So he wasn't being deliberately misleading. He just happened to be wrong because somebody was dishonest with him. What the attorneys actually know is pretty limited. It's pretty limited. And so even when you look at NAPOE cases, there are situations where there's just not a lot of wiggle room. It's pretty black and white. The one that just came down recently, the Glossip case, that was the witness testifying that he doesn't have, mental illness, hasn't seen psychiatrist. The prosecuting attorney knows this is untrue because he has the medical records. He has the records. He knows that's untrue. Really not a lot of wiggle room about that. So sure, if she testified and she was going to lie, it puts the defense in a bad situation. You always have that risk, but it's honestly, it's pretty low. And you don't make that assumption about Karen. Why would you make that assumption about Karen? And not about the other witnesses, particularly some of the ones that we have seen already be so squirrely with the truth. Lola the good dog. A Hank left unchecked closed Fed case becomes ARCA is biased. Feds are in cahoots with Karen Reed. Karen Reed told Feds to investigate Commonwealth. No accountability. Yeah, I mean, he has really taken that far beyond what it supports, even if it is true, hasn't he? He's turned that into, this is exonerating. They've been exonerated, that it's been a finding of some kind that there was no wrongdoing. That's not what an investigation being closed means. There can be a lot of reasons to close an investigation that have nothing to do with, have they made specific findings. There can be certainly situations where they've decided there's been wrongdoing here, but for priority reasons, we're not going to prosecute. For other types of policy reasons, we're not going to prosecute. Policy changes, personnel changes, we've talked about a lot of that stuff. Statutes of limitation can expire. Doesn't mean that the feds have found they didn't do it. Just means maybe the feds lack the ability to prosecute it. So this idea that it's exculpatory really does seem to be stretching it. And of course, my concern is that if he does go down that road, the defense should be able to correct that. The defense should be able to point out, well, it's weird that you're saying the feds exonerated everybody when there is a letter from Joshua Levy to the judge in this court, or not to the judge, I think to Michael Morrissey, but it's been filed in this court, that they have a very different understanding and interpretation of what happened to John O'Keefe than the Commonwealth does. That's pretty exculpatory. So if the door is going to be opened, the door should be open for both sides. Would it be? That's the $1 million question, of course. But it's really lurking in the shadows with so much of this case, not just the risk that Hank is going to try to get something like this out through somebody. I don't know who. He's not going to put Mr. Morrissey on the stand. He's not going to put Helena Rafferty on the stand. Who else is there? He's not going to put himself on the stand, So I think it's unlikely that he would go down that road. This is the press stuff. This is the PR stuff. This is part of the PR war where he puts it in his pleadings. It's not substantiated. It doesn't lead to the conclusion that he's trying to use it to support, but he's just trying to get as much leverage out of it as he possibly can. So I agree. He's taken that far, far further than the circumstances particularly justify. Cam, I'm saying the Commonwealth has violated NAPUI. I see. Yeah, potentially. Potentially. I mean, I thought they violated NAPUI with the inverted video. The inverted video. Does this fair and accurately depict and the whole deliberate concealment of the fact that it was inverted? Yeah, that seems like a NAPUI problem to me. Even now getting into Trooper Proctor. That was Buchanan. Now we got Proctor and the whole story about the elementary school. When did they get that report? When did Mr. Lally get that report? Didn't disclose it before cross-examination. Didn't disclose it before he elicited any of this stuff. The defense could have chosen, you know what? Maybe instead of objecting and moving to strike, we'll cross him on it, had they known. But it wasn't disclosed. And in that respect, the Brady standpoint, it doesn't matter if Mr. Lally knew about it or not. Law enforcement knew about it. They have a duty to disclose it. And as soon as Trooper Proctor is going to open his mouth and make these accusations that are contradicted by that report, now we know it's exculpatory. They have a duty to disclose it. Didn't do that till 7 months later. So yeah, that's not Napoli I'm talking about there. But if he did know about it when Proctor made those statements, and why would he not? How would he not? He was continuing to do these, drips and drabs of disclosures and new reports and so on and so forth. Investigations ongoing. They're investigating. They have information about this witness prep happening, and I'm supposed to believe he didn't know about that. I find that very, very difficult to believe. Can they prove it? That I don't know. But yeah, this Napoli is an issue, and it's been an issue. I expect it to continue to be an issue. Brady has been an issue. I expect it to continue to be an issue. And yet, not a single even caution from the judge. You guys better get your act together. Nothing. Bird, love to red bird dog. Yeah, red bird dogs are the best. Those are my old men, or my old man and my baby girl. Those are Vizslas. Those are my red bird dogs. They are wonderful dogs. They just don't live long enough. But I mean, no dog does, but thank you so much for that. Well, guys, I guess we're coming back Thursday. I guess I get to sleep in tomorrow, and we'll be coming back Thursday. See what develops in the meantime. I don't know, man. This case is getting hard to keep up with as we're in this flurry. See if more things get filed. I'm going to just keep my eyes open and do my best to keep track of it and stay on top of it until we come back on Thursday. I have to say, for selfish reasons, I kind of hope we don't start on the 1st. Although, in fairness, even if we do start on the 1st and it's jury selection, that's not going to be televised. So there probably won't be anything to live stream because I'm pretty sure we've got a Koberger hearing on the 1st. And I got a lot of catching up to do with you guys on the Brian Koberger case. So, wouldn't necessarily break my heart to miss that first day. If something is happening, I won't. But if there's nothing going on, then I probably will focus on that instead. But I am working on that. So as far as what to expect, I'll be here Thursday. I'm continuing to work on, like I promised, I'm going to get that video out about the juror interview, kind of my thoughts about that, my reactions to that, some of the specific things that stood out to me as noteworthy. Probably going to watch that documentary. I don't know. It depends. The main reason I want to watch it is not because I expect it to be frankly good or objective or thorough or really anything like that. I've just lost faith in unfortunately in the documentary industry, so to speak. It's just so rare that you get one that's actually got any kind of depth to it. But just because if, as we've seen, Karen is giving interviews in it, it's kind of important to know what those statements are, I think, how they could affect, her prospects for a second trial. One of the things that I have mentioned in terms of Karen being a witness and the potential difficulty of that is that all of these interviews that she's given, these are potentially prior inconsistent statements. If she deviates from it in any way, that can be a problem. And I say that with some caution because I don't necessarily expect her. Like I said, I don't expect her to lie. I don't expect her to lie. But that doesn't mean that the Commonwealth can't try to find little things that are like minor deviations, and try to, blow those up into something bigger than they are. Because if there's one thing prosecutors love, it's she changed her story type of narrative. They love the person changed the story. And oftentimes, like we talked about with Delphi, it's not a change in the story at all. It's that they gave you a sort of general description of something, and then you told them go back and give us details. So then they gave you details, and then you're like, oh, well, they added stuff. Well, yeah. Uh-huh. But if they really don't like you and they want to make you look guilty and pin it on you, they'll be like, well, they changed their story. It doesn't require at all that there be a direct conflict between something that you said the second time and something that you said the first time for them to try that strategy. So that's where I see the risk, not that she would say the wrong thing or that she's, going to be impeached with all this earlier stuff. It's that it's just extremely likely to be twisted and distorted. And that's a risk for the jury if they don't like her. Again, I don't think that's where they'd likely lean, but you just never know. If they don't like her, then they can really seize on that. If they're expecting her to prove something to them and they think maybe she's not that reliable, she's changed her story, they can hang their hat on that as well. But also just the risk that it's annoying as shit when prosecutors do that. It's really annoying. And so you just have to be as prepared as best as you can for the fact that's likely to happen, and be prepared to deal with it. Karen's a smart woman. I think she can. I really do. I think she can handle stuff like that. But you just have to be very, very cautious, because of the risk that you come off as defensive, you come off as combative, you just give these other impressions that maybe you haven't intended, uh, that just aren't necessarily the benefits you want to get from being on the stand in the first place. So anyway, that's the reason why I would watch the documentary. I am interested to see what she has to say. Um, that said, if there's enough reporting out there that I can rely on, that lets me know, maybe I'll watch that. I normally tend to prefer primary source stuff, but the thing is that with a production, you already know, like I said, you're not getting the whole picture. You're getting what's edited, and so you know how good of a source is it? I don't know. I don't know. Is it better or worse than somebody telling me what the documentary says? I don't know. So I'm thinking about that. It just depends on kind of what I have time for and what else is going on. Those things are on the horizon. Still doing a lot of work catching up on Mr. Koberger and everything that's kind of gone on in that case. As those of you following it know, there have certainly been developments there. 911 call is out. Yeah, I heard it. There's been the text messages between the roommates the night that this was happening. At least some of those are out. Fair amount of new information, and I think for a lot of people, it is raising maybe more questions than it does answers. So I certainly have some thoughts about that. Of course, new filings and stuff all the time. We've just got motions in limine now coming in, and just the whole kind of the similar posture with Karen Reed, where we've got a slew of stuff coming in. Richard Allen, I do want to just briefly address. I don't plan on doing a video about the Bridge Guy video. Folks have seen the Bridge Guy video has been released. Here's all I can say. all I can say, guys, memory is what it is. I'm the first one to acknowledge that memory is not a recorder. It can be flawed. It's just as good as you want to give it credit for. That said, my memory of this particular video being shown at the trial, this is the one they said was enhanced. That's my memory. Because the one that they showed that they told us was the original, you really could not see Bridge Guy. And I'm not the only person who reported that. That was pretty much the universal takeaway after that original video was played in court. And bear in mind as well, this was when we were all so intently looking for Bridge Guy, because that's the point of this video. That's what we want to see. And the original was so shaky and moving around that we're straining to try to see him and can't. So when he became visible behind Abby for, a second or more, that's what I remember from when they enhanced the video. That's pretty much all I can say about that. So I think there's a lot of confusion maybe about what's what and how does this all add up. And I think I've seen folks question very legitimately, well, why would you even need to enhance this one? It seems pretty good quality. It seems like you can hear stuff. Yeah, exactly. Exactly. So the bottom line is that we need to get those trial exhibits. When we get the trial exhibits publicly released, as they should be, as the public records that they are, then everybody is going to be able to see for themselves. Here's what was presented. Here's what it was represented to be. And then we can all gauge it together. We'll all be on the same page, the way we should have been from day one. It shouldn't have been a big secret about who gets to see what, when, and so forth. So that's really all I intend to say about that. In Mr. Allen's case, the appeal has been filed. I see Judge Gold did release a snarky letter saying even for us unserious, illegitimate media folks, the exhibits are public records. So if we pay her $25 by check or money order, she'll send a thumb drive. When, how, I don't know. But apparently there has been some movement there, at least in principle, that the trial exhibits that are not sealed are going to be publicly available from her court. If not, I did also check with Ms. Weinecke that once they get transmitted up to the Court of Appeals, that is also potentially an avenue to be able to get a hold of those. If Carroll County doesn't want to do its job and provide public access, an alternative might be to go to the Indiana Court of Appeals. So about all I have to say about that. So yeah, guys, coming up Thursday, we'll be back. We'll see what happens in the meantime. Look for some new content on Koberger, on the juror interview, possibly on the documentary, and otherwise getting ready for trial to start soon. So we'll just see how this all unfolds. Thank you everybody for joining me. Thank you so much for your comments, for your awesome chat. I love this chat so much. This chat loves and appreciates smart people. That's what I love about it so much. It's just always such a good resource. People with good information, good backgrounds and experience, willing to share that. I love the kinds of conversations we're able to have about stuff like that. So thank you all for being here, for contributing. Thank you for your well wishes for the old dog. I hope he has plenty of time left to sit and snore through Karen Reed trial 2. If Mr. Lally or if Mr. Brennan is going to argue like he did the motion on Dr. Wolf, that had a little bit of a lally lull moment to it. I was starting to like, oh, what's he talking about? He's just listing off things. Yeah, the snore could accompany that pretty nicely. So thank you again. Really appreciate all of you, and hope to see you guys again on Thursday. We'll see what we get. We'll see what we get. Maybe I'll put up a poll. Are we going to have a trial or not? Maybe I'll put up a poll on X. I don't know. We'll see. Thank you again, everybody. I will look forward to being back here bright and early Thursday morning, and I hope to see you all then. See you soon.